If we could have the jury trial.
Yes, no.
You can see it.
All rise. All the jury is present and accounted for.
All right, thank you, Mr. Bailey. Please be seated. All right, good morning, everyone. We're back on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. This is the second day of introduction of evidence in the state's case in chief. I'll note the state is here and present. Mr. Wood was conducting examination of a witness. Mr. Wood, is the state ready to proceed this morning?
Yes, sir.
Very well. I'll also note the defense is present, along with counsel and the defendant. The court also notes the jurors are all properly seated and all 18 jurors have returned. The court's also confirmed that the jurors each completed their affirmation this morning regarding not looking into the case during the break. And so we appreciate you following that admonishment as well. One other matter I just wanted to bring up before we got started with additional evidence is the court's live streaming this hearing in this trial. There is I heard there were some complaints that the audio maybe wasn't coming through very well on that. I'd ask the attorneys if they could to talk right into the mics. Of course, that helps as well with our court reporter making the record. In addition, the live stream comes directly through the court's official channel. That can be somewhat difficult to find if you go to the Idaho Supreme Court website. However, there is a website on Ada County about this trial, and if you just Google the term Ada County Daybell trial, there's an easy link to find for the court's official live stream, and that's the most direct signal. So for those that are observing the trial online, if you're having any issues with audio or quality of the signal, perhaps you could go to that direct signal, which is the best source of the live stream proceeding. So with that, then we had Detective Hermosillo was on the stand yesterday, and I believe you're continuing direct examination. Is that correct, Mr. Wood?
Yes, Your Honor.
All right, I'll have the witness recalled then if you're ready to proceed with additional testimony.
Thank you.
All right, Detective Hermosillo was sworn in yesterday. I'll remind you, you are still under oath for your testimony today. And to confirm, not being the state's case agent, I just want to confirm that you didn't review any, well, you're the first witness, so we don't need to do that on this particular witness. So, Mr. Wood, if you'd like to just inquire on further direct, you can do that this time.
All right, thank you. Good morning, Detective. Second, when we finished off yesterday, we were discussing what you had found or what you had observed at a burial site, and just for purposes of the jury, what site were you at when you found the body you were speaking of yesterday?
We were at the site that we deemed JJ's burial site.
And where, Your Honor, if I could be given State's Exhibit 10A. And if I may publish that?
Yes, it's admitted, correct?
Yes.
So,
Detective, if you could, just for purposes of clarification, with a pointer, point out the location you were speaking of.
It's the burial site on the other side of this pond, just underneath this tree.
Okay. Now, you call it a pond, when you were out there on June 9th, was there water in it?
No, there wasn't.
And again, just to clarify, when we had left off your testimony yesterday, is it correct that what you observed was what appeared to be a small body wrapped up in a black plastic bag?
That's correct.
Your Honor, I'd ask that the witness be handed State's Exhibits 10B through 10M. Detective, can you review those exhibits and let me know when you got a chance to? Detective, do you recognize state's exhibits 10B through 10M?
Yes,
What do they purport to be?
photographs, there's a photograph of the west side of the defendant Daybell's residence. And photographs of the backyard.
And do you know when these photographs were taken?
On June 9th, 2020.
Were you the photographer?
No,
But you were on the property that day.
that's correct.
And were you able to observe each of the areas that are photographed in these exhibits?
Yes,
You saw them with your own eyes.
yes,
And are these true and accurate representations of what you observed on June 9th, 2020?
yes.
Your Honor, I move for admission of state's exhibits 10B through 10M.
Any objection?
Judge, just to,
Into the microphone, please, Mr. Pryor.
I'm sorry, Judge. Judge, just one here on 10B if I could. Otherwise, I'm fine with the rest of the exhibits.
Okay, so let's do that then. So 10C through 10M have been offered or admitted, and Mr. Pryor, you can board there in 10B.
And officer, you're looking at 10B, is that right?
Yes,
For
sir.
now.
Yes,
And the vehicle that's parked in 10B, is that the vehicle that was, the position of the vehicle at the time that you testified about Mr. Daybell?
that's not the vehicle that Mr. Daybell was in. That one.
Do you know what vehicle that is?
The driveway looks like a Subaru.
Okay, is that the driveway that you're making reference to?
That's correct.
So in other words, somebody else's vehicle is there. We don't know whose vehicle that is,
It's not the one that Mr. Daybell was in.
but you don't know whose vehicle that is.
I don't know whose vehicle that is.
You don't know when the vehicle was put there.
No, sir.
You don't know who the owner of the vehicle is.
That's correct.
I'm going to object, Judge, on foundation.
All right, Mr. Wood.
Thank you, Your Honor. Detective. So you don't know whose vehicle that is, correct?
Correct.
You were still there that day. Okay. Do you recognize this as Mr. Daybell's residence?
Yes, I do.
And this is a true and accurate representation of Mr. Daybell's residence.
Yes, it is.
Your Honor, I think significant or sufficient foundation has been laid.
All right,
Judge, I just make a record that I'm objecting also on the basis of relevance. It looks like it's a picture of a vehicle in the driveway.
okay. Well, the picture shows many things, including a vehicle. I'll allow the state to have this admitted, and sufficient foundation's been established, so 10B is admitted as well as the others.
Detective, if you will, or Your Honor, may I publish?
Yes.
Detective, what did you observe in State's Exhibit 10B?
That is the west side of the Daybell residence. When I testified earlier to coming out and standing in the lawn area, that's not the vehicle that Mr. Daybell was in, but it was similarly parked that way back in. And that's the driveway he was sitting in when I was observing him look over his right shoulder toward the pond area.
Detective, do you have the pointer with you? Can you point to where you were standing when you initially observed Mr. Daybell's behavior?
I was standing here in this area.
And then you said that you positioned yourself so that you could see what you thought he was looking at.
That's correct.
Where did you go then?
I stood more towards the driveway area. The vehicle that Mr. Daybell was in was up further this way. It wasn't backed in as far as this vehicle in the photograph.
And just to clarify, is that when you looked back and saw the activity under what became the first burial site?
Well, I was looking forward at that time. I was facing this direction. And I aligned myself with Mr. Daybell, who was up here more, and he was looking towards this area here.
Now, can you see the first burial site from where you're, from that location?
Yes, it's the tree I spoke about earlier. This is the tree where JJ was buried underneath. This right here is the pond. You can see just a little bit more taller shrubs around the top of the pond area. But this is the tree that JJ was buried underneath.
So is it fair to say that even from the front or the middle of Mr. Daybell's front yard, you can see that location easily?
That's correct.
Detective, what did you observe in State's Exhibit C, 10C?
When I testified, I was tasked with sifting through the fire pit. This is what we deemed the fire pit. It had burnt tree limbs. There was various little pieces of trash. It was in the middle of round cinder blocks. So that's what we deemed the fire pit as.
And the way it appears in that image, that's the way you found it that day.
Correct, it was that morning, yes.
And what do you observe in State's Exhibit 10D?
This is just north of the driveway that Mr. Daybell was sitting in, looking in the same direction. So we're standing on the west side looking east. And that is the tree. And then here's the pond area right here.
Detective, I'm going to put up State's Exhibit 10A again, and if you can point to the approximate location of where this picture was taken from.
So that last photograph was taken from this area right here.
And so it's fair to say from that location, you can easily see burial site number 1.
Judge, I'm going to object at this point. There's been some leading questions. Continues.
I'll sustain that last question, so they do.
Right. From that perspective, what were you able to observe?
Burial site, number 1, JJ's burial site.
Was it difficult for you to observe it from that location?
The actual grave site on the ground, yes, from that location, but where the tree and the pond are, no, it wasn't difficult.
Detective, what did you observe in State's Exhibit 10E?
So when I testified earlier about the difference in length of grass and shrubs in that 6x6 section that was marked off next to the pond, this is what I'm referring to. If you look close, you can see there's smaller grass and dirt protruding right here. This is probably a little bit difficult to see. There's probably a better photograph. But this is longer shrubs through here, and then in here was like the length of sod and some dirt where there was nothing growing.
And when yesterday you testified being called over to burial site 1, is that what it looked like when you got over there?
That's correct.
Detective, can you describe to the jury what you saw in State's Exhibit 10F?
So when I spoke about ERT removing the topsoil and the top level of shrubs, this is what I was speaking about. And you can start to see the 3 large white rocks I was talking about earlier starting to come through the dirt.
You testified yesterday about a smell. Was this the same time that you began to smell what you described yesterday?
Yes, as soon as they removed this and, the topsoil, that's when I instantly can smell the smell of a decomposing body.
Detective, can you tell the jury what you saw in State's Exhibit 10? Or I'm sorry, 10G.
So as the ERT team methodically removed the soil around the white rocks and dug down just a little bit deeper, this is what we saw. You can start to see there was a smaller rock, but the three large white rocks started to show through clearly. When I testify that there was thin wood paneling underneath the white rocks, you can start to see the edge of that piece of wood paneling underneath the rocks. We also noticed that there were roots cut that the ERT team didn't cut. They were already pre-cut. Some of the roots are fairly thick, so that was something we observed as well in that burial site.
Detective, can you describe for the jury what you saw in State's Exhibit 10H?
After the ERT team removed the white rocks, this is the two pieces of wood paneling that were underneath.
What did you observe in State's Exhibit 10I?
I spoke earlier about the distinction in soil. Some of the soil looked wet or moist, some of it looked dry. Excuse me. What you're looking at here is once we remove the wood paneling, this is what was underneath, and you can start to see the distinction through here of the wet soil. And up here is just the dry soil. So the rocks and the paneling were all through here. So that was the other thing that we observed. And as we took the paneling off, the odor began to become a lot stronger. So we knew we were at the right spot.
Your Honor, I apologize for any delay. I wonder if we could just have a very brief sidebar regarding the removal. All right.
Mr. Wood, you can continue.
Thank you. Detective, can you explain to the jury what you observed in State's Exhibit 10J?
So once we started removing the wet soil, and I testified earlier to a black round object protruding through the dirt, this is what we started to see. It appeared to be like tight wrapped black plastic. It wasn't very too far underneath. It's fairly shallow, but that's what we started to see. And I talked about what appeared to be the crown of the human head.
Can you describe what you saw in State's Exhibit 10K?
So once that appeared, ERT team leader Steve Daniels used a small, sharp instrument. And I testified that he made a slit through the black plastic. And you can see the black plastic kind of peeled away on the top of the head. And then I testified there was a white piece of plastic underneath. And this is the white piece of plastic here. He made a slit in the white plastic. And when he did that, you can see what appeared to be brown human hair. Some of the hair kind of came out with the sharp instrument, and that's the hair you can see on top of the white plastic. But that's what you're looking at there.
Can you tell the jury what you observed in State's Exhibit 10L?
Once the ERT team continued excavating, they removed all the soil on top of this small body that was wrapped in completely black plastic. I testified that it appeared to take the shape of a small body in black plastic. And this is what we saw here. It's probably a 4x2 grave, and I'm guessing at those measurements. But it started to take the shape of a small body, and then it had different pieces of duct tape throughout the black plastic on top.
What did you observe in State's Exhibit 10M?
Once we lifted JJ out of the ground, there was still wet soil underneath where he was laying. And that's body decomposition. The body had begun to break down. So that's what the wet soil is through here. Again, you can see the roots that were cut to be able to put him in this location.
Detective, once that body was recovered, what did you do? And to clarify that question, once that body was taken out of the ground, what did you do?
I assisted the coroner and a few other officers in placing JJ in a body bag, a black body bag. Coroner locked the body bag for evidence. We then put it in the back of the coroner's vehicle. The coroner and a Fremont County deputy drove the vehicle up to the morgue, and myself and Lieutenant Rockwell followed behind that vehicle. Once we were at the morgue, JJ was placed in the morgue, and then we returned back to the Daybell residence.
Do you recall who the Fremont County coroner was?
Brenda died.
And do you recall what other officers traveled with you to the hospital?
In my vehicle was just Lieutenant Ron Ball. With the coroner, Brenda Dye, I believe it was Detective Kaigon.
And just for clarification, you had said this already, I apologize, but what hospital did you take them to?
Madison Memorial Hospital
And where is that located?
in the city of Rexburg.
Once you finished that task, what was the next step for your investigation?
We returned back to the Daybell residence. As we got there, we were told that they had possibly,
Judge, I'm gonna object at this point. There's some hearsay.
I'll ask another question. Without telling the jury what anyone told you, what did you do when you got back to the residence?
we assisted in a second burial site.
And when you got back to the residence, did you observe another burial site being looked at?
I did.
Where was that located?
So through the course of our investigation, we learned that the Daybell family had deemed a section of the backyard as what they referred to as a pet cemetery. And we knew through talking to family members that the pet cemetery had a little black dog statue next to a post that kind of signified where the pet cemetery was. And so when I returned back from dropping JJ off at the morgue, I observed ERT digging in the pet cemetery area.
And did you aid in that excavation?
I did.
What did you personally do?
ERT began taking off top layers of soil in this specific area in the pet cemetery. Once they began to again see wet soil start to protrude through the dry soil, they slowed down, and we got on our hands and knees and began excavating that by hand.
And by hand, did you use tools to do that?
We did. They had small tools that we could use, trowels, like paintbrushes, things of that nature.
Approximately what time of day was this?
Say it was afternoon.
And approximately how many people were there with you using hand tools?
There was only a few of us at a time that could work because of the area, but also because of the smell. We had to take turns digging because we were on our hands and knees, and the smell was so bad that you could only work for a few minutes before somebody else had to take turns, get on their hands and knees and start digging by hand.
And you said the smell, what did it smell like?
Decomposing body.
How long did you aid in that excavation using the hand tools?
Hours, probably.
And did you find anything?
We did. We ended up digging down and started to uncover burnt pieces of flesh, charred bone, fatty tissue. Just, and I apologize for the lack of better words, but globs of burnt flesh starting to protrude through the dirt.
And once you found that, how long did you keep working that site that day?
We worked probably until probably 4-ish in the afternoon.
And you mentioned ERT, were they working there alongside you?
They were, there was also other areas being excavated as well, the fire pit still. So everybody was kind of tasked with something different at that point. And once we started getting down a little bit more in Tylee's burial site, we assumed it was Tylee, we could start to see the top of what appeared to be something plastic and green. And at that point, the ERT team leader, Steve Daniels, decided we were done for the evening.
When you were done for the evening, what happened?
We had Fremont County Sheriff's Office, the Madison County Fire Department, bring in 2 large light trucks to illuminate the crime scene. The crime scene was taped off. We had officers from Rexburg City Police, deputies from Fremont County Sheriff's Office that remained on scene all night long, walking the perimeter to make sure that the scene wasn't compromised. And it was well illuminated.
And did you return the next day?
Yes, we did.
And when you returned the next day, who else returned?
Everybody that was there the previous day.
So ERT came back
That's correct, yes.
and other members of the FBI,
Yes,
Fremont County officers,
yes.
Rexburg police officers.
Correct.
And I believe you testified earlier that there were some attorney general investigators there as well.
Yes,
And they were all there that second day.
that's correct.
Approximately what time did you arrive that second day?
We started fairly early. It was approximately 7 in the morning.
And what did you start doing when you got there on the second day?
I went back to Tylee's burial site. We had put up canopies to keep sunlight and wind. There was media, helicopters flying overhead, so we wanted to keep the scene from being compromised as much as we possibly could. And at that point, we got back down on our hands and knees and began digging again with those same little tools to get down to see what exactly we were going to take out of the ground at that point.
And so and then what happened next? Did you continue to do that work?
Like I said, we would take turns digging because the smell was so bad. And we would just keep excavating slowly around this green object that started to come through the dirt the first day. So it started to take a shape, a roundish shape, when we began digging down and methodically removing dirt. And at that point, we could start to see what appeared to be the shape of a green melted bucket that appeared to have the remains of, we assume, were Tylee that were charred and burned inside it.
And were you there for the excavation of that bucket?
Yes.
How did that happen?
Once we got down to what we thought was the bottom, of the disformed bucket, we observed part of a human skull underneath the bucket. There was some teeth that we ended up excavating from underneath. At that point, the goal was to lift that out of the ground. And so there was a little, we made kind of a little hole around it to try to get underneath. So we put tarps out. Like I said, the goal was to try to lift it completely out without manipulating it in any way. But when we tried to do that, when we lifted it, it all broke apart because there was nothing holding it together. So at that point, we had to go back in and remove all the pieces of the charred flesh and burnt bone and organs and pieces of Tylee that put onto the tarp.
And while you were doing that, you talked about the smell, and is that still present?
Yes, very much so. Strong odor, yes.
Were you able to observe the lack of a better word, total removal of that green bucket and its contents from that excavation site?
We were able to lift everything out at that point. We put it on the blue tarp. There were photographs taken, measurements taken by ERT. Once that was completed, we dug down even further to make sure we didn't miss anything. Once we figured out everything was out of the ground, that tarp and those and Tylee's remains were then put into a body bag. In the corner again, lock the body bag for evidence purposes. And Tylee was also transported to the morgue.
And did you follow along when Tylee was transferred to the morgue like you did in JJ?
We did, we followed in the same manner. Myself and Lieutenant Ball. Once Tylee was placed in the morgue, we returned back to the Daybell residence.
Your Honor, I'm going to be asked that the witness be handed State's Exhibits 11A through 11G.
And Judge, for the record, I've previously reviewed these and I would object to admission of these as exhibits.
All right, exhibits 11A through 11G are admitted without objection. This time, as we get into this evidence, I'm gonna announce that because of the graphic nature of some of this evidence, I'm not going to be showing this on the court's live stream, nor to the general public in the courtroom. The jurors will be viewing the evidence as well as the parties are permitted to see that. In addition, the court will provide an opportunity for any victims that wish to see the evidence in a private setting to view it as it's now been admitted into the record. But we made arrangements to not display this to the general public. And so, Mr. Wood, with these exhibits, that's how we'll proceed. And we will not include that on the live stream, but you can discuss it on the record in open public with witness.
Detective, can you review that exhibit, those exhibits? And Your Honor, I understand these are already admitted. I am still ask a few foundational questions just to establish knowledge.
Very well for the record.
Detective, what does states exhibit 11 and 14? And its subparts?
Photograph of pet cemetery and photographs of Tylee as we took her out of the ground in her burial site.
And were these photographs taken on June 9 and 10?
That's correct, yes.
And were you on the scene that day when those photographs were taken?
Yes,
Are they true and accurate representations of what you saw?
yes,
Your Honor, those exhibits having been admitted, I'd ask to publish.
You can do both.
Detective, before I publish that, I'm going to place State's Exhibit 10A up again. And can you point to the general location of what you've described as the pet cemetery?
right here.
So can you have on the record and explain where it's pointing?
Yes, Detective, will you explain where you're pointing?
It's just east of this shop area and just north of the fire pit. So it's right through here.
And Your Honor, I do think that the state's first picture under State's Exhibit 11 is okay for public consumption.
It is. I just wanted to make sure our system was working as well, that exhibit 11A is fine.
Detective, what did you observe in State's Exhibit 11A?
This is where we began excavating briefly. As you can see in this photograph, there's a small black dog statue next to the post. So that's where we had learned this was the pet cemetery area through talking to family members. And then there's just some tarps laid out for some of the soil. You can see in the back the markers that had been distinguished and laid out by ERT for the fire pit area that I had talked about earlier.
And Your Honor, I think at this point it's appropriate to turn to public access.
I agree.
Detective, Your Honor, I'm at a bit of a, I have no idea if this is, I can't see if this. Well, I'll ask, Detective, can you see that image in your monitor?
Yes,
Can you see most of it?
yes.
Can you describe for the jury what's been marked as State's Exhibit 11B? What did you observe there?
Can I see? Is there a way I can use the pointer?
I have a suggestion also, Mr. Wood, just because I understand what you're doing to try to line that up since you can't see the monitor. Do you want to set a notepad or something on there and get it oriented that you could set on top of that just so that it's lined up?
And if I could have the screen for 1 moment, thank you, Your Honor, for that suggestion. Detective, what did you observe in State's Exhibit 11B?
It's hard to describe that, but I'll do my best. In the middle of that photograph, you can start to see the different color and changes in the soil from dry to a wet, moist dirt. You start to see to the left just a little bit of that area. You can see the white piece sticking out and it's burnt on top, and that's charred bone that's starting to stick out, and all the little pieces next to it are pieces of burnt flesh, tissue, where we later determined were organs that were all kind of, that's the top of what was inside the bucket. So that's what we first started to see when we started to excavate.
And at this point, were you still using the hand tools?
Yes.
You explain for the jury what you observed in State's Exhibit 11C.
So as we started to excavate down further, some of the top of the mass of burnt flesh wasn't really attached to anything. And so when we would start to dig away towards the sides, it would kind of come apart. It wasn't part of that original mass. And so what you're looking at on this blue tarp is burnt flesh still attached to some bone. The upper left part of that section that you're looking at is part of the hip bone that still has burnt flesh attached to it, and then dirt and just fatty burnt tissue.
You described for the jury what you observed in State's Exhibit 11D.
So when I talked about it started to take a roundish shape, this is what I'm referring to. And we dug around the sides of it, trying to get to the bottom, because like I said, the goal was to get underneath, have 3 or 4 guys in there and just lift it onto the tarp. So that's what you're looking at in this photograph, is just the burnt flesh. It's still just kind of inside that.
And Judge, could we approach for a sidebar, please?
Yes.
And that's part of a human skull just to the right of that, the green bucket. There were teeth there in the dirt as well. But that's what you're looking at, it's just a close up of the bottom of it.
Detective, what, can you explain for the jury what you observed in State's Exhibit 11 as?
So once we removed that mass, and put it on the blue tarp, there was still some wet soil underneath. So we dug down even further to make sure that we had excavated everything we needed. And so what you're looking at, you can see the tarps in the background we had put up. You can see some of the hand tools that we used just to the right of that hole. But that's what you're looking at, is just after we got that mass out, the wet soil.
Detective, what did you observe in State's Exhibit 11G?
So these were part of Tylee that kind of broke apart when we tried to lift it out of the ground. There's pieces of charred bone, there's parts of a skull on the bottom left, covered in dirt, and they're still burnt, rotting flesh still attached to the bone. So that's what you're looking at that one. These were the pieces that broke off.
Detective, I believe you testified that you assisted in transferring those remains to Madison County to the hospital, correct?
Correct, I followed behind in the corner.
Was Lieutenant Vallow with you again?
He was.
Once you got up to the hospital, what did you do?
We observed the Fremont County coroner, Brenda Dye, transfer Tylee's remains into the morgue. The morgue was unlocked, but there was evidence they put up. And at that point, myself and Lieutenant Ball went back to the defendant Daybell's residence.
And what did you do when you got back there?
We assisted and made sure there were no other burial sites or anything that the ERT team needed assistance with. At that point, we decided that we were going to take JJ and Tylee to the Ada County Coroner's Office to have an autopsy performed. So roughly 4 p.m. on June 10th, 2020, it was decided that we were going to follow the county coroner with the remains of JJ and Tylee to the Ada County Coroner's Office for an autopsy the next morning.
And when did you arrive in Ada County, approximately?
Approximately 8 or 9 in the evening on June 10th.
And what did you do once you got there?
We went directly to the coroner's office, and JJ and Tylee were dropped off, and the coroner's office took custody of both JJ and Tylee.
So that was later in the evening.
Correct.
Was an autopsy performed that night?
No.
When was the autopsy?
The autopsy,
Judge, I'm gonna object. There needs to be some foundation.
Overruled, if you know, you can answer.
the autopsy was performed June 11th, early morning hours.
That was the next day.
Correct.
And were you present for that?
Yes, I was
And where did that autopsy take place?
at the Ada County Coroner's Office.
So when you arrived at the coroner's office, what did you do first?
Initially, when we arrived, we had a little debrief with the medical examiner, Garth Warren. He told us what he expected.
Judge, objection.
Grounds,
Hearsay?
sustained.
You met with Dr. Ward.
Correct.
What was the purpose of that meeting?
To debrief us on what to expect that morning.
What did you do next?
We went to the room where the autopsy was performed. Put the sanitary booties on our shoes, signed in on a whiteboard with our name and cell phone numbers. So he had a record of everybody that was in the room. And at that point, we stood back against the wall and observed the autopsy.
Now, as a detective, you don't perform an autopsy, correct?
Correct.
But you were able to see it take place.
That's correct.
And what did you observe happening during that autopsy?
One of his team members brought out the body bag. And I recognized it to be the same body bag that we took from defendant Daybell's backyard that day because it still had dirt on it. It still had the same lock. And at that point, they opened the body bag and revealed the same black plastic and small body that appeared to be in the black plastic.
And then what did you observe?
Dr. Warren and his team cut down the middle of the black plastic to open up what was inside. At that time, I observed a small child with duct tape on his head from his chin to his forehead area, tightly wrapped around his head. He had red pajama pants on, red pajama shirt. He had his arms folded this way across his body. And there was duct tape from elbow all the way around to his other elbow. He had his ankles also bound with duct tape. He was still wearing his nighttime pull-up diaper. He had black socks with the word Skechers in orange. I could tell that he was going through various states of decomposition based on his skin color.
Judge, I'm gonna object.
Grounds,
He doesn't have the experience to make a determination about the levels of decomposition. He's speculating.
I'll sustain the objection and strike the final part of the answer about decomposition, Mr. Williams.
Right. Detective, what did the body's skin look like?
The skin was sloughing. It appeared to be bluish green, black, yellow. And through my training experience, going through and handling different dead bodies at different stages of decomposition, that's what I read.
Judge, I'm gonna object again. There's been no foundation for him to make that sort of medical assessment. He's not a medical doctor.
Your Honor, my argument would be that's not a medical assessment. It is on his training experience.
I'll overrule the objection. If you'd like to cross further, you'll have a chance, Mr. Pryor. The objection is overruled. Foundation laid in the previous response.
Detective, once this, the body was taken out of the bag and you made the observations that you've just described, what happened next?
Dr. Warren and his team then cut the white plastic that was wrapped around his head and duct tape. They cut down the middle to reveal what was underneath. At that point, I observed another piece of duct tape stretched from JJ's jawline to jawline over his mouth. He also cut the several layers of duct tape from his arms, and it revealed some more duct tape that had his wrist bound underneath all those layers of duct tape. He then took his bottom pajamas off and shirt, and it also revealed the nighttime pull-up diaper he was still wearing.
Now, Detective, you spoke about the duct tape and bag over the head, correct?
Correct.
And you've been referring to this as JJ.
Yes.
Until that duct tape and bag were removed, though, were you able to identify him as JJ?
No, once they removed the duct tape in the bag, through looking at all the photographs for the last 8 months of JJ, I recognized him to be the same little boy laying on that table as JJ Vallow. He had the same hairstyle, shorter on the sides, longer on top. At that point, I recognized him as JJ.
Once the clothing was removed, what did you observe happen next?
Dr. Warren pointed out some bruising on his arms, on his ankles, on his chest. He also pointed out some scratch marks on the left side of his neck, just under the duct tape. At that point, Dr. Warren and his team performed the autopsy.
Your Honor, I'd ask that the witness be shown states exhibits 12A through 12B.
A through B.
E.
B, thank you.
Detective, can you review those exhibits? Let me know when you've had a chance to.
Yeah.
Do you recognize states exhibits 12A through E?
Yes,
What do they purport to be?
JJ Vallow laying on the table after they opened the black plastic.
And were you present when those pictures were taken?
Yes.
You were in the same room.
Correct.
Are those true and accurate representations of what you observed that day?
Yes.
Your Honor, I'd ask that state's exhibits 12A through E entered into evidence.
No objection, Judge.
Very well. 12A through E are admitted. All of these are graphic in nature, will not be published or shown on the court's live feed or public in the courtroom. They'll be published to the jurors, however you wish to split.
Thank you. Detective, can you describe to the jury what you observed in state's exhibit 12A?
Once they removed the black plastic that JJ Vallow was in, this is the first thing we saw. You can see on the white plastic on top of his head, that's the slit that was made when his head was sticking out of the ground. And you can see the duct tape I testified to wrapped around his entire face. His red pajamas are still soaked with body decomposition. The level of duct tape on his arms is what really caught my attention. And he still has the white, he has a white and blue child blanket wrapped around him.
Can you describe to the jury what you observed in state's exhibit 12B?
This is the JJ's legs, his bottom half, he has his red pajama pants on still. His ankles, like I testified, are wrapped with duct tape. Those are his black Skechers socks that he had on. It's hard to see there too, but his legs and body are also soaked with decompositions.
Can you describe to the jury what you saw in state's exhibit 12C?
When I spoke earlier that Dr. Warren cut down the white plastic and the duct tape that was covering his head, this is what we saw. You can see the other layer of duct tape around his mouth that went from jawline to jawline. You can see his hair, brown hair still was matted down to his head. Wet, so with body decomposition. But at that point, I was able to still recognize him as JJ Vallow.
You observed in 12D.
That's the white bag that was covering his head. That looks like blood in the bag. It's actually body decomposition, just breaking down. It appeared to be a normal trash bag. It had a red drawstring. And you can see, if you look close at the waffle style pattern, the expandable type trash bag. There's still pieces of duct tape that are attached. That's what that photograph depicts.
Can you describe to the jury what you saw in 12B?
That's just another photo of JJ. The tape is starting to lose its stickiness because of the way the body is. It's just a different photo or a different angle of JJ's face.
Could I have a recite bar, council? Bit earlier than normal, but we are going to take a mid-morning recess at this time. We'll reconvene here in about, slightly before 10:30 to get started with additional testimony.
All rise, please.
Gentlemen, you are not allowed to close down. Please exit the courtroom.
Thank you. Please be seated. Council, if you're ready, we'll have the jurors brought back in.
All rise. Jury is present and counted upon.
Thank you, Mr. Bailey. Please be seated. We're back on the record then on case CR 22-21-1623, just concluded the morning recess. Detective Colonel CEO is still under oath, and Mr. Wood, if you'd like to continue with your direct, you can do that at this time.
Detective, I think when we left off, we were speaking about the autopsy of J.J. Vallow, correct?
Correct.
You had mentioned earlier that you did observe the actual, not only the body, but then the autopsy of J.J. Vallow.
That's correct.
And were you present for that entire autopsy?
Yes, I was.
And when that autopsy was concluded, what did you do?
At that time, Dr. Warren and his team removed JJ from that autopsy table. Then they brought out a second, excuse me, black body bag. And I recognized it to be the same body bag from the scene because it also had dirt. And they placed that body bag on the table.
And what did you observe next?
Dr. Warren and his team opened the body bag, looked at the remains for what was left as far as remains inside. He stated there was nothing he could do at that time with an autopsy, so.
Judge, I'm going to move to strike as hearsay,
Your own statement already came through.
and I'm going to move to strike.
So
Could you repeat the question?
What did you observe? What were you had just talked about the Tylee's remains being brought out. What did you observe?
Once the remains were brought out, Dr. Warren opened the bag and looked at the remains and stated there was nothing he could do at that point. So at that time, we left the autopsy room for the day.
And when you left, did you do anything in furtherance of your investigation that day?
No,
Did you return to the Ada County Coroner's office the next day?
we did. On June 12th, 2020, we went back to the Ada County Coroner's office. At that point, Lieutenant Wall took custody of some of the evidence and we transported it to the state lab in Meridian.
And were you with Lieutenant Ball when you did that?
I was, yes.
And once you took it to the state lab, what did you do?
Those items were checked into the state lab. And then that concluded what we did for that day.
Detective, you spoke earlier about some of the other agencies you've worked with in this investigation. And is it correct you worked with Fremont County?
Correct, yes.
And I believe you testified that your primary focus in this investigation was looking for Tylee and JJ. Is that accurate?
Yes, that's accurate.
Was there an investigation in Fremont County at the same time that had connections to your investigation?
Yes, there was.
What was that investigation?
Fremont was investigating the death of Tammy Daybell, who was married to the defendant, Chad Daybell. Kind of the exact same time we were doing our investigation with missing children.
And would you meet with Fremont County and discuss the cases together?
Yes, we would.
And would you aid each other in those investigations?
Yes,
Would you share information?
yes.
Detective, are you aware of any event involving Tammy Daybell on October 9th, 2019?
Yes, I am.
How did you become aware of that event?
Through the course of sharing information with the Fremont County Sheriff's Office, we were advised.
Judge, can we approach?
Yes.
All right, I want to have the court reporter, if we could, read back Mr. Wood's previous question before the sidebar, and then I'll see if there's an objection held by defense.
Question, how did you become aware of that event?
Is there an objection to that, Mr. Pryor?
No, not to that question.
Okay, then Mr. Wood, just proceed with another question.
I don't think there's no objection to the question. I don't think it's been answered yet.
Okay. You can answer.
We were advised through the course of our investigation that
Judge, I'm going to object at this point. The question is whether he was advised, not what he was advised of, but whether he was advised.
Our response, Mr. Wood,
Not quite sure I understand that objection, Your Honor.
I don't as well, so you can continue with your response.
Can you repeat the question? Please.
How did you become aware of the events of October 9th, 2019?
Through the course of our investigation, we were aware of those events through speaking with Fremont County Sheriff's Office.
Why was it important to you in investigating your case to share information and receive information from Fremont County?
It was important because the suspects in that case were the exact same suspects in our case. And so we wanted to make sure that we shared information so nothing was missed. At that point, we were still looking for two small children. And so it was imperative to us that we shared information and gathered information from neighboring counties and anybody that was involved with this case.
And did you also confer with Arizona law enforcement?
We did, yes.
Detective, are you aware of who Charles Vallow was?
Yes.
Who was he?
Charles Vallow was married to Lori Vallow.
Is he alive?
No, he is not.
Do you know when he died?
Charles died July 11th, 2019.
Are you aware of how he died?
Charles was shot by Alex Cox, Lori's brother.
Now, you testified earlier that your initial involvement in this case involved looking for a Jeep.
That's correct.
And I believe, correct me if I'm wrong, I believe you testified that you were looking for that Jeep because it was requested by Arizona law enforcement.
That's correct, yes.
And are you aware of why they were looking for that Jeep?
Yes, I am.
Why were they looking for that Jeep?
That Jeep was a suspect in an attempted homicide of Brandon Boudreaux, who was married to Lori's niece, Melanie Boudreaux. The suspect in that homicide was also Alex Cox.
Detective, going back to October 9th, 2019, Tammy Daybell, are you aware of the incident that took place with Tammy Daybell?
Yes, I am.
What was it?
Judge, I'm going to object. There's no foundation as to how you became aware of it.
Sustained.
Through your investigation, did you become aware of what happened to Tammy Daybell?
Yes, I did.
And how did you become aware of that information?
Sharing information with Fremont County.
And so was this part of the collective knowledge of the case that you were?
That's correct, yes.
And did you aid in that investigation as well?
I did.
So you personally became aware of these events?
Correct.
Based on your knowledge and your investigation, are you aware of any event involving Tammy Daybell on October 9th, 2018?
Judge, again, there hasn't been proper foundation.
I think at this point I've established that it's through his investigation and knowledge.
This objection is overruled.
You can answer the question.
Yes, I'm aware.
And what was that event?
On October 9th, 2019, Tammy Daybell believes that she was shot at in the driveway of the defendant Daybell's residence.
And when you say shot at, are you aware of how she thought she was shot at?
She initially reported that it was possibly a paintball gun.
Detective, in your investigation, did you ever put together timelines of events that took place?
Yes, I did.
Why is it important to do that?
Just to establish who the key figures were, and the key dates to aid in our investigation, so we can make sure that we share the accurate and correct information with the other agencies.
And in preparing for this trial, did you prepare any charts of key figures to aid the jury in understanding your testimony and the testimony in the trial?
Yes, I did.
And was that based on your involvement in the case
Yes,
and your investigation?
correct.
And based on I'm sorry, that wasn't very well said. Based on the information you gained from your investigation.
That's correct.
Your Honor, I'd ask that the witness be handed State's Exhibit 30. Detective, do you have State's Exhibit 30 in your hand?
Yes, I do.
What does it purport to be?
Those are the key figures that I put together as far as the investigation goes, photographs.
And did you do that to aid this jury in understanding who the people involved in this case are?
Yes,
And did you do that in anticipation of your testimony?
yes, I did.
And are those, the pictures attached with those names, are those true and accurate representations of the individuals attached to those names?
Yes, they are.
Your Honor, for demonstrative purposes only, the state would move to enter State's Exhibit 30 into evidence.
Any objection?
For demonstrative purposes, no.
Very well. Exhibit 30 is entered for that reason.
May I publish?
Yes.
Detective, if you can just use your pointer and just, for purposes of the record, read the names attached with each picture.
Sure. This is Lori Vallow Daybell, Charles Vallow, Alex Cox, who was Lori's brother, Chad Daybell, Tammy Daybell, his deceased wife, Tylee Ryan, who is daughter to Lori, JJ Vallow, who's a son to Lori, and Melanie Pulowski Boudreaux, she was remarried, is the niece to Lori Vallow.
And when you say that JJ was Lori Daybell's son, was he also Charles Vallow's son?
Yes, he was.
And that was by way of adoption, correct?
That's correct.
And so Alex Cox was JJ and Tylee's uncle.
Yes.
Detective, similar to that last chart, did you prepare a timeline in anticipation of your testimony?
Yes, I did.
And did you do that based on your experience and knowledge of the case?
Yes, I did.
And it was based on information you gained through your investigation?
That's correct.
And did you do that to aid the jurors in understanding just the basic timeline of the events that happened in this case?
Yes.
Your Honor, I'd ask the witness be handed State's Exhibit 31.
Judge, could we approach please for the sidebar?
Yes.
This time, ladies and gentlemen of the jury, there's an evidentiary issue to resolve, which we are going to take up outside of the presence of the jury. We'll do that as quickly as we can. So I will be off the bench while I research this momentarily. Then we'll come back on and make a ruling outside of the jury's presence, bring them back in to evidence.
All rise, please.
Maybe see. Court hearing session.
Thank you. Please be seated. All right, we are back on the record on CR 2221-1623. We are going to take up an objection outside of the presence of the jury as it relates to the state's proposed exhibit, in this case particularly state's proposed exhibit 31. And the court had to go back and review some prior rulings in the case that occurred some time ago. I've done that now, so what I'd like to go through is the proffer and determination if there's still a objection to the exhibit and make a ruling on that outside of the jury's presence. So Mr. Wood has offered exhibit 31, which is a timeline, and Mr. Pryor, does the defense maintain an objection to the admission of that timeline?
Judge, I spoke with Mr. Blake.
I spoke with Ms. Blake, and procedurally, I think at the time that the 404B was filed by the state, we were also dealing with the severance issue, is what I recall. And then she discussed that with me. So I think I may have made a non-objection to the 404B. And I think I made a record of that when Mr. Thomas and Mr. Archibald were objecting to that. So I may forego my objection because I think my recollection is I don't have a record of it, Judge, which is a little unusual, but I think I may have noted on the record to the court that I'm not objecting to the introduction of 404B evidence.
All right, I understand. I think there was lodged an objection back February 14th of 2023 by you to the 404B motion. Does the state have any clarification on that, Mr. Wood?
Your Honor, just based on recollection, I believe it was not an objection to all of the state's intended 404B, but to some of it. And my recollection, and I'm not looking at any document, this is just my recollection, was that the defendant did stipulate to some of the 404B, including issues dealing with Charles Vallow and Brandon Boudreaux. That's my recollection.
And Judge, my recollection is that I did file a timely objection, but then at the hearing, there was, and I'm going back, Judge, and we're talking 3 years ago, and I'm just going off of recollection as well. That's Mr. Wood is. I believe that I filed an objection, and then at the time of the hearing, I may have orally stated that I'm not objecting to the introduction of the Brandon Boudreaux or the Charles Vallow information, and Mr. Thomas and Mr. Archibald continued theirs, and the hearing was continued on, and somewhere in the interim, Judge, there was a severance order granted, and I don't know whether I was part of the 404B motion. That's where I'm having some difficulty in recollection. My records don't show an order that you granted the 404B in this case, so I don't see an order in this case.
Okay, so just to clarify, there was an objection was filed on behalf of Mr. Daybell by Mr. Pryor, February 14th, 2023 to the 404B. We then had a hearing on the 404B evidence on February 22nd, 2023. The court then issued an oral ruling on the record, and in that oral ruling went through different evidence that was sought to be proffered under 404B. And among the rulings the court made on the court minutes under paragraph 9, specifically referencing consideration of the shooting at Mr. Boudreaux, the court weighed out the 404B arguments and found that it would be admissible at trial. And then in the hearing, I did indicate that I'd gone through the analysis for 404B, looking at the State versus Fox case, doing a two-tiered weighing of the factors, balancing them out with the evidence proffered, and ultimately, and I'm looking at the transcript of this hearing where I may be overruling, determining finally, quote, the court does find there is relevance under tier 1, parts 1 and 2 for the introduction of that evidence. And then I looked at rule 403 to see if there was probative value to substantially outweigh the danger of unfair prejudice, and finally determined that as to the attempted shooting of Brandon Boudreaux, there would be more probative than unfairly prejudicial, as it would relate back to the purported plan of the defendants. So the court did find that the state was permitted to introduce that 404B evidence. So as we stand here, knowing procedurally that's the ruling, on the timeline, I guess I'll first come back to this proposed Exhibit 31 and ask if there's any objection at this point for the defense, Mr. Pryor.
No, Judge.
Okay, so Exhibit 31 then has been offered and will be admitted. I would also note on the record, but I think the door has been open to discuss that anyway based on opening argument as well. But for that reason, and also based on the court's prior determination made, I am going to permit that reference on 404B evidence. The reason I'm still discussing this for counsel is I think this now triggers a requirement that I give a limiting instruction to the jurors about how 404B evidence is considered. And I do have prepared a limiting instruction that I am going to advise them of at such point as after your exhibit's been offered, Mr. Wood. Okay. Okay, thanks for the delay there. We can bring the jurors back in, please. This is, I don't know where the, I've got the actual.
And Judge, if I could just quickly inquire before the jury comes back in, if the court did have both pages of that in its,
I only have first page.
okay, once we get done with this one, I'll bring that up.
Okay.
All right. Jury is present and accounted for.
All right, thank you. Please be seated. All right, ladies and gentlemen of the jury, apologies for that delay. We were working through an evidence issue. I will note that the state has offered Exhibit 31, which has now been admitted by the court. It's a timeline. It does make some references in there that, for me at this time, I think would be best to give the jurors a special limiting instruction. So I'll read this instruction to the jurors at this time. Ladies and gentlemen, during the course of this trial, evidence will be introduced for the purpose of showing that the defendant committed acts other than for which the defendant is on trial. Such evidence, if believed, is not to be considered by you to prove the defendant's character or that the defendant has a disposition to commit crimes. Rather, such evidence may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, plan, or absence of mistake or accident. So that instruction provided, Mr. Wood, if you'd like to proceed with that exhibit.
Your Honor, I don't have any.
Well, I believe the witness does.
May I publish?
Yes.
Just briefly before I do, Detective, before we took a break, we spoke about timeline you had prepared.
Correct.
And the reason you prepared that was to aid the jury in understanding the events of this case.
Yes.
If you can take your pointer and go through these events and just read them into the record.
July 11th, 2019, Charles Vallow dies. September 2nd through September 3rd, 2019, Lori, Alex, and the kids, JJ and Tylee, moved to Rexburg, Idaho. The last known proof of life for Tylee was September 8th, 2019. The last known proof of life for JJ was September 22nd, 2019. The attempted shooting at Brenton Boudreaux, Gilbert, Arizona, or attempted homicide, October 2nd, 2019. The attempted shooting of Tammy Daybell, October 9th, 2019. The death of Tammy Daybell, October 19th, 2019.
And if you'll continue on the second page.
November 1st, police receive a call about a Jeep. The Jeep was located November 4th, 2019. Chad and Lori get married in Hawaii, November 5th, 2019. Welfare check on JJ, November 26th, 2019, which is the same day Alex and Chad were contacted. The Rexburg Police Department searched Lori and Alex's apartments November 27th, 2019. Search warrant served on the Daybell residence was June 9th on 2020. JJ and Tylee were taken to the Ada County Coroner's office June 10th, 2020. And the autopsy was conducted June 11th of 2020. Thank you.
Your Honor, I have no further questions for this witness at this time.
All right, thank you, Mr. Wood. Mr. Pryor, cross-examination.
Judge, would the court like me to start, or would you, or like to take a break at the lunch break?
Let's go ahead and get started with cross and go till it was, please.
Good afternoon, all. Good morning, officer.
Good morning, sir.
We do know each other. We've at least exchanged pleasantries a couple of times
Yes, sir.
in the past. And I guess for purposes of this hearing, would you prefer that I refer to you as lieutenant or officer?
Lieutenant's fine.
Mr. Pryor, Apologize very much for the interruption. I wanted to confirm something on that last exhibit. It was entered by the court. Is that a demonstrative exhibit?
That's what I understood.
Either as a demonstrative or a summary.
Okay, thank you, counsel. Apologies for the interruption.
Judge, I'm also looking for the, oh, I found it. So Lieutenant, you've been involved in a number of aspects in regards to this case, is that right?
That's correct.
You've done some investigation on your own in terms of welfare check with Lori Vallow, is that right?
Yes,
But you've also interviewed a number of witnesses, is that correct?
yes,
You interviewed Melanie Gibb, David Warwick, right?
yes.
Several times?
Few times.
And you've interviewed a number of other witnesses as it relates to this case, is that correct?
Yes,
Okay, now you previously discussed your role as a police officer and investigator in this case. And I guess I want to clarify something if you could, please. As a police officer investigating a case, your role is to conduct an investigation, right? Look at the facts.
correct,
Try to establish and gain some information, right?
correct,
But you're not supposed to judge one way or the other, right? You're supposed to remain neutral,
that's correct,
and you're not supposed to narrow that role as a police officer to a particular person. Is that correct?
that's correct,
In other words, you're supposed to look at the evidence as a whole. And rather than focusing on one person and saying, we're going to assume this person did this, and we're going to build our case around prosecuting that person, that would be inappropriate, wouldn't it?
Right.
Your role is actually to look at all the evidence, consider all the evidence. And once you've gathered all the evidence that you think is relevant to a case, what do you do with that evidence?
we follow the evidence,
Okay, and then once you follow the evidence, you've established a report or you've come to concluding your investigation, what do you do with that evidence that you've concluded with?
we put a case together,
Okay, and then do you provide it to someone?
we provide it to the prosecutors,
Okay, so there's distinct roles as part of a criminal case. You'd agree with that, right?
yes,
And your role is to conduct an investigation, correct?
correct,
Look into all possible evidence of any kind, correct?
that's correct,
And view the evidence, right?
yes,
Not make any determination as to what that evidence means, but rather gather as much evidence as you think is relevant in your mind and put together a compilation of that evidence, correct?
correct,
Okay. And then at that point, only at that point, do you provide it to the prosecuting attorney and they make a determination as to whether or not they will pursue charges against them. Do you understand? Is that the way you understand the process is supposed to work?
yes,
Okay. And if you were not to follow that process, if you were not to follow what I just described, that wouldn't be appropriate. There's protocols. You agree with that, right?
yes,
Okay. And you should never blend the roles of a police officer with the role of a prosecuting attorney. You would agree with that, right?
explain what you mean by blend the roles.
Well, I mean, it's not a prosecutor's role to show up at an investigation when you're conducting an investigation and engage in part of the process of interviewing witnesses. You agree with that, right?
I've had prosecutors show up to certain investigations.
Okay, but that's not the norm, is it?
I think it depends on the investigation.
Okay, okay. So in other words, you think that it's appropriate that if a prosecutor is deciding whether to pursue charges against somebody, that they should also participate in the interviewing of these witnesses as part of that process. Is that what you're telling me?
I think it's important for a prosecutor to have all the information.
Well, doesn't that create a problem in your mind?
No, sir.
Okay. Well, let me talk to you a little bit about that. Because if you're doing an investigation and you're really remaining neutral as part of that investigation, right? You're not supposed to make judgments, correct?
Correct.
You're supposed to look at the evidence, gather all the evidence, and then make a determination of what evidence you want to submit to a prosecuting attorney, right?
Correct.
Do you ever get involved in the process of deciding whether someone should be charged or not?
What do you mean by that, sir?
Well, after the evidence is all gathered, and after you've done your report as a police officer and put together all of the information, do you ever go over to the prosecutor's office and say, you know what, I put this evidence together, and you know what, I want to have a discussion with you about whether or not we want to charge this person? That wouldn't be appropriate, would it?
I'm gonna object as argumentative.
Sustained.
Okay. But would it be appropriate for a prosecutor to interview witnesses and inject their personal opinion in those processes of interviewing witnesses? Would that be proper under any circumstances?
And I'm gonna object as argumentative.
I'll overrule that objection.
And could you repeat the question again?
Yes. But would it be appropriate for a prosecutor to interview witnesses and inject their personal opinion in those processes of interviewing witnesses? Would that be proper under the circumstances?
To interject their personal opinion?
Yeah.
I would say probably not.
Okay. So if you're engaging in name calling or making references to a person's character in a case, that would clearly be an inappropriate act, would it not?
Objection beyond the scope, Your Honor.
That's sustained, and that's facts, not evidence.
Right. Now, you spoke a little bit about this body cam issue. And you said that it was a policy that there's only one body cam among 7 or 10 of you as detectives. Is that right?
No, sir, I never once said it was policy. I just said there was only one body cam.
Oh, so,
Between 7 detectives.
so in other words, you share a body cam. It's not a policy within the department.
Correct.
Okay, is there a policy in the department about recording or trying to preserve a record when you're interviewing witnesses?
Yes.
Okay, what's that policy, sir?
When we conduct interviews at the police department.
Yeah.
Those interviews are recorded.
Okay. Now, what about if you're out in the field and you're conducting an interview? Is that to be recorded as well?
There's no policy that says it has to be recorded.
Okay. Do you carry a microphone as well, officer, other than a body cam?
No, not on my person, I don't.
Okay. Do you carry a cell phone while you're doing that? That's issued by the county.
Do I keep the cell phone in my car? Yes,
I didn't ask you that. I said, do you carry a cell phone when you go out in the field?
on my person or in my vehicle?
Either one.
In my vehicle.
Okay. And does that cell phone have the technology that allows you to record or photograph and videotape images?
Yes, it does.
Okay. So what I understand is on November 26, 2019, you were directed your folks to go out to the Vallow residence. Is that right?
That's correct.
Okay, and you said that you were with Ron Ball. Is that who you said you were with?
At one time, yes, I was with a couple different officers that day.
Oh, so tell me who you were with on that day. Remind me.
Detective Dave Holt,
Okay,
Detective David Stubbs,
okay.
and Lieutenant Ron Ball.
So there were 4 of you who went out there to locate or to find out some information about what again? Remind me.
About the whereabouts of JJ Vallow.
Okay, and this was a concern that you had because you were contacted by another law enforcement agency expressing concern about the safety of a young child, right?
No, sir.
Okay, tell me what was the purpose?
It was a simple welfare check.
Okay. And you went out on this welfare check and there were, if my math is correct, please correct me. Did all 4 of you detectives and lieutenants go out at the same time?
No, sir.
You went out at different times.
Myself and Dave Holt went out initially.
Okay, and then when did the other 2 officers show up?
When I called them based on the lies that I had been told.
Okay. And these lies that you've been told, at that point, you and Detective Hope, neither of you decided to bring a video camera, right?
That's correct.
And neither of you decided to wear a recorder to record any of the incidents that took place about these so-called lies, right?
That's correct.
And nobody took out their phone and recorded it or made a video or audio recording of the discussion with Mr. Daybell or Mr. Cox on November 26, 2019, right?
That's correct.
And even after you said these so-called lies, even after you discovered that, Mr. Daybell apparently told you something that you didn't think was true, at that point, did you instruct any of the officers who were coming to aid you? Maybe it's a good idea we should bring an audio with, or a video camera with us, or a mic to record some of these statements, because I have some concerns. Did you
Objection,
think
that's
about
not
that?
the
We did that, sir.
Hold on.
I'm going with that. There was an objection and sustaining the objection. So, strike the answer. You can ask another question, Mr. Pryor.
And it was Detective Stubbs who had the video cam, is that right?
That's correct, sir.
And that was when you video cammed Miss Vallow, about when you had contact eventually with Miss Vallow, is that what the video camera that you're talking about?
I didn't have contact with Miss Vallow.
Now, I'm a little confused about something. And maybe you can clear this up. You said that you asked Mr. Daybell first about whether he had Lori Vallow's phone number, correct?
No, sir, I didn't contact Mr. Daybell till after I contacted Alex Cox.
Okay. At some point, did you ask for Lori Vallow's phone number from Mr. Daybell?
Yes, I did.
Okay. And at no point did you ever make a threat to him saying you're going to turn this phone number over to us, right?
No, sir.
At no point did any other officer walk up to him and say, if you don't turn this phone number over, you're going to get yourself in a lot of trouble. That never took place to your knowledge, right?
That's correct.
Okay. But then after that, you're saying, at first he said, I'm not going to give you the phone number. And then out of the blue, he decides to give you the phone number.
Objection misstates the facts and evidence.
Okay. Then subsequent to that, he
Hold on,
decides,
Mr. Pryor. When there's an objection, I'm gonna rule on it before you launch into another question. So the objection is sustained.
subsequent to that, he decides to give you the phone number. Is that right?
Can you repeat the question, please?
I'll go back over the analysis here.
Thank you.
Your testimony is that Mr. Daybell refused to give you the phone number at first, correct?
That's correct.
And that was an adamant refusal. He said, no, I don't know what her phone number is, right?
That's correct.
And then without any further prompting by the police officers or any encouragement by law enforcement, he shows back up and gives you the phone number later, right?
Objection is misstating the facts and the
Well,
evidence.
I'm trying to establish the facts, Judge.
The objection's overruled. If the witness has an answer, you may answer.
You say he showed back up. He never left when I originally asked him.
Okay,
I had to ask him twice to get the phone number.
okay. And how much time passed between the first request and the second?
Roughly a minute.
Okay. So without any prompting by the police, he asked him for the phone number. He denied, and then within 60 seconds, he said, oh, here's the phone number. Is that what your testimony is?
When Detective Hope started walking towards us and I re-asked him again, that's when he gave me the number.
So you had to ask him twice. Is that what you're saying?
That's correct.
Now I'm gonna kind of bounce around a little bit, okay? Please bear with me, okay? You made a comment about supposed paintball guns, and if I misquote your testimony, please correct me, okay? You said something about a supposed paintball gun incident with Tammy Daybell, right?
Yes.
Okay. And then you later on decided that it was the words you used were a shooting. Is that the word you used?
Probably.
Well, you were just here testifying a few minutes ago, and just used the word shooting when Mr. Wood talked to you about that, right?
Yes.
Okay. Now, as part of your investigation, you've had a chance to look at all the evidence, right? In this case, you got access to almost all the evidence in this case,
That's
right?
correct.
And have you gone through all the evidence in this case?
Yes, I have.
Okay, and did you look at evidence of facts and circumstances surrounding the Tammy Daybell incident on October 9th?
Yes.
Okay. And Judge, just bear with me.
Your Honor, if he's gonna be showing evidence digitally, can we put our screen back up?
Yeah.
Not sure I'm gonna be up there, but okay. Now, I would represent to you that we previously stipulated to the admission of a number of exhibits in this case. And one of the exhibits is exhibit number 16. Okay? And the parties that previously exhibited, Judge, we've already moved it, it's already been exhibited. So what I'm gonna do is show you exhibit 16, okay?
And this is one already admitted.
It's already been admitted, Judge, previously. Now, you talked about facts, and you used the word shooting is what you used, right? With Tammy Daybell?
Correct.
And you don't believe that Tammy Daybell was shot at with anything other than a paintball gun, do you?
Objection relevance.
Overruled.
You don't believe that Tammy Daybell was shot with anything other than a paintball gun, do you?
Yes, I do, sir.
Okay, and what do you base that on?
The evidence through our investigation.
Okay, and part of your investigation is did you look at the Tammy Daybell evidence that she provided to your office?
To my office or Fremont County?
Fremont County.
I did.
Okay. And one of the pieces of evidence is exhibit number 16. Judge, I don't see it going on.
All right, counsel, if you'd like, we could take a lunch break or we can keep moving on here from that.
Here we are, Judge.
Okay.
Okay, and officer, I'd have you turn to the screen and see if you can read the screen. Just read it. Not out loud, just to yourself. Let me know when you're done.
I'm done, sir.
Okay. And I would represent to you that this is a email from Tammy Daybell to her friends in the Salem 3rd Ward of her church. Okay? And would you start with the word something and read the email to me?
Something really weird just happened. I want you to know so you can watch out. I'd gotten home and parked in our front driveway. As I was getting stuff out of the back seat, a guy wearing his ski mask suddenly standing at the back of my car with a paintball gun. He shot at me several times, although I don't think it was loaded. I yelled for Chad and he ran around the back of the house. I have no idea what his motive was, and he never spoke, even after I asked him several times what he though.
Okay. So, and do you see the date on this email? It's just about friends there.
Are we gonna object to this being characterized as an email?
I'll sustain that.
Okay.
Do you want to clarify, Mr. Farr, what type of communication it is?
Well, it's a communication to the friends of the church, and I think it's a text
I'm
message.
sorry.
I can. I believe it's a text message. Judge, I may have misstated that it was an email.
Okay.
My apologies. So this text message went out to all of the friends of the Salem 3rd Ward. It's an LDS ward over in the town of Salem, right?
I can't answer
I
that.
don't know. You know where the town of Salem is, right?
I do.
And that's a town that's close to Rexburg?
Correct.
Okay. And obviously, you can't answer that about the ward or anything like that, but obviously the term ward would suggest that it's some sort of a religious group of folks they're talking to, right?
Correct.
Okay. But this email doesn't say that she was shot with a gun, or there's even a mention of a gun. The email talks about a paintball.
Again, I'm gonna object to characterization of this as an email. It needs to be
Except
short.
for judges, it's gonna be.
I'm sorry. We'll speak for-
Yeah. When there's an objection, Mr. Dragon, gotta have time to get it on the record, make a ruling, and then respond, please. So sustained, this states the evidence.
Text.
I'm also gonna object to this being described as a text message. There needs to be some foundation for what this evidence actually is.
Judge, I don't need a foundation. This has been admitted as an exhibit. This is
All right.
it.
I'll overrule that objection. Jury can review it in the format it came in with the screen capture.
So at any rate, this message from Ms. Daybell to the people of the third ward doesn't say that it was a gun, does it?
Does say it's a gun, it just says it's a paintball gun.
Oh, it says paintball gun. You're right. Okay.
Yes, sir.
It doesn't say any other gun, right? If there's any confusion about that, right?
Not in this email or text.
Okay. Did you also have an occasion to look at the, I'll be bringing that up later, but the search engine from Tammy Daybell's account?
No, I did not look at the search engine for Tammy.
Were you aware that, and I'm gonna hack his name, but one of the officers, Officer K, whatever his name is, Officer K, was provided email, search information that Tammy Daybell engaged in regarding paintball guns in a picture. Are you aware of that?
Objection calls for speculation.
I'm asking whether he's aware of it.
Overruled.
Are you aware of it?
I was aware that he was provided information. I can't tell you exactly what information he was.
Okay, we'll get to that in another day. But did you also listen to the 911 call that was made regarding the paintball incident?
I did.
Okay, and there was no mention of a gun in that 911 call, right?
No,
The mention in the 911 call is that someone took a shot at me or tried to take a shot with a paintball gun, right?
that's correct.
Okay, so the suggestion today that it was a gun is based on your own hunch, right?
No, sir.
Well, do you have the gun?
I have evidence of Google searches done by Alex Cox around that time.
Okay. Do you have information as to where Alex Cox was at the time of this alleged shooting?
Yes, sir.
You do have evidence of that?
He was at the Daybell residence earlier that day.
I didn't ask you on the day of the Daybell residence, at the time of this shooting. Do you recall when this shooting took place?
I believe it was maybe 8 in the evening, maybe.
Right. And let's clarify this, because the data that you have regarding him being at the residence was much earlier in the day, right?
That's correct.
And you don't have any data that shows that Alex Cox's phone dinged or any other communication device that Alex Cox had was at the location of the house at the time of this paintball incident, do you?
At the time, no, sir.
Okay. And so at this point, the information you're talking about is there's some Google searches by Alex Cox, correct?
That's correct.
And the information is that you've decided to not take into consideration Tammy Daybell's own statement about a paintball gun?
Objection misstates his testimony.
Sustained.
So what other information are you leaning on to suggest that this was anything but a paintball gun?
The Google searches performed by Alex Cox talked about shooting through Dodge Dakota.
Okay. And I appreciate that. And that would be one of Chad and Tammy Daybell's vehicles. Is that correct?
That's correct.
Okay. Were you aware of who was driving the Dodge Dakota at the time that incident took place?
No, sir.
Okay. Did you talk to any of the family members, any of the 4 children about who was actually the driver of this Dodge Dakota that Alex Cox was trying to figure out a way to shoot through?
We attempted to contact those children and they wouldn't speak with us.
Okay, so you don't know whether Chad Daybell or Tammy Daybell were driving that Dodge Dakota, right?
That's correct.
So the reality is that, Tammy Daybell was driving the Dodge Dakota. It sounds like Alex Cox had something for Tammy Daybell. Is that what you're suggesting?
I'm not suggesting that. I'm just simply stating what Mr. Cox's Google searches were around the time of that shooting.
Okay, and you're basing those Google searches on your position that you believe this was a shooting, right?
That's correct.
Okay, so if Chad Daybell was driving the Dodge Dakota during this time, and he was the primary driver and maybe the only driver, would that mean then you would be looking at whether Alex Cox was trying to shoot Chad Daybell?
Chad Daybell didn't call in a 911 call and said he was shot at. Tammy Daybell.
Yeah, but Tammy Daybell called in a 911 call about a paintball gun. And it was a paintball gun. And we'll have Officer Cannon talk about that. And we'll listen to the 911 call.
Objection, that's not a question.
Well, the question is,
Mr. Pryor, again, you've got to give me an opportunity to rule an objection. If it is sustained, let's just argue it's not a question. You can ask another question.
the shooting and the call that was taking place was in reference to a paintball gun incident, wasn't it?
Can you repeat the question, sir? I couldn't hear you.
The call that was made regarding this incident was a 911 call about a paintball incident, wasn't it? They used the words paintball in the 911 call.
That's correct.
We'll move on. Okay. Now, we previously talked about, and Judge, I don't know when you want to stop. I've got a ways to go.
I think this probably is a good time for the lunch break, even though so we will take our lunch recess. That'll be an hour. We'll plan on coming back on for additional testimony around 10 and a quarter after 1.
All rise, please.
Thank you. Please be seated. Mr. Pryor, you ready to continue with your cross-examination?
Yes, Judge.
Okay, we'll go ahead and have the jurors brought in.
Mr. Judge, would you prefer I wait?
It's up to you. You can go take the podium if you'd like, or you can wait at Chelsea's table.
All rise, please.
The jury is present and counsel.
Thank you. Please be seated. All right, we are back on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. The defense is conducting cross-examination of the witness, Detective Hermosillo. Mr. Pryor, if you'd like to continue, you may.
Officer Hermosillo, I'm going to take my time. I didn't probably eat too much coffee this morning, so I waited that over the lunch hour. Now I think I'm okay. Let's hope so. I think the judges admonished me enough at this point that I think I got the point. So we're going to go a little slower if you don't mind. So I want to go back to the paintball incident. And you said that one of the pieces of evidence was that Alex Cox had Googled a black Dodge Dakota, correct?
He Googled what caliber it would take to shoot through the windshield of Dodge Dakota.
Was it the windshield?
Yes, I believe so.
Okay. Judge, there's previously been an admission of Exhibit 34 by stipulation. That's the Homer J. Maximus with a reference to the state as well. And we'll get back to that in a minute, but there was at least a reference at some point that there was going to be trying to find out what kind of caliber it would take to penetrate a Dodge Dakota vehicle, at some point, windshield or otherwise, correct?
Correct.
And you took that as a threat, as a means of saying that's why Alex Cox was trying to kill Tammy Daybell.
That Google search, along with him being at that residence that same day earlier,
Okay,
and the incident involving Tammy Daybell,
okay, okay,
that
okay. And that's what drew you to that conclusion, is that correct?
that's correct.
Okay. So we don't know who was driving the Dodge Dakota regularly, do we? Because you didn't speak with the kids, is that right?
That's correct.
Okay. And we do know that on the day that you said Chad Daybell, at least you were alleging that Chad Daybell fled on sometime in June 9th. Is that right?
Objection misstates the testimony.
Well, try to clarify that. High rate of speed, Chad Daybell left the area. Is that fair?
That's fair.
That's what you're stating, correct?
That's correct.
And in the vehicle that he was in, do you know that that was the Dodge Dakota that supposedly he was fleeing in?
It was not Dodge Dakota he was fleeing.
Okay, what vehicle was he fleeing in?
I can't recall off the top of my head. We have it in impound, but it wasn't the Dodge Dakota.
Okay. Okay. So there were two vehicles, an Equinox and a Dodge Dakota.
Which day, sir?
On June 9th, there are two vehicles that the Daybells owned, an Equinox and a Dodge Dakota. So which one was it that he was allegedly fleeing?
I just stated I couldn't recall the vehicle that
Okay.
he was arrested.
Okay, that's fair, that's fair. So, just to recap, we know that there was a Google search by Alex Cox on his Homer J. Maximus account, correct?
Correct.
And that there was an allegation that someone was, or that Alex Cox was trying to figure out what type of caliber to at least shoot at a black Dodge Dakota, correct?
Correct.
Okay. We don't know who the target was, or who was the target was in that Dodge Dakota, but we know it was someone who owned the vehicle, obviously, right?
Well, I would assume so.
Okay, okay. Now, that's what you based on the fact that you thought that there was an attempt on Tammy Daybell that day, correct?
Correct.
Okay. Now, when you read that email from the Homer J, or the research from the Homer J. Maximus account, did you take into consideration the date of when that search took place?
I did.
And when was that?
I can't recall. I have to refer to my notes.
Okay. I'm gonna take the liberty of helping you out a little bit. At least I think I'm gonna help you. There. Judge, I don't know why it's not going up on the screen.
Is this a exhibit?
34.
Sorry, which 34 has sub exhibits? Is
I
that
believe it's A, Judge.
34A is admitted previously by stipulation. 34A is what you're trying to publish, Mr. Clark.
Yes, Judge.
I don't know if there's one can assist to see it, but okay, it is admitted.
There we go. I'm sorry, and I don't know what. All the best laid plans to prepare for this. So I'd like you to take a look up at the screen, if you would. Look at the date of when this search took place.
Okay.
And what is that date
October 12th,
of?
2019.
Okay, now what was the date that allegedly Tammy Daybell was shot at with a paintball gun?
October 9th, 2019.
So if I understand, the incident with the paintball gun took place 3 days before this search took place.
Correct.
Okay, but you still continue to believe that was the basis for someone going after Tammy Daybell, is that right?
That's correct.
Okay, all right. But you don't have any Google searches that suggest anything else in a threatening manner. This is the one and only that you're relying on, is that right?
No, that's not right.
All right, what else are you relying
If you scroll up on October 9th, I believe that evening,
on? Okay. Go ahead.
Alex Cox Googles how to make an AR-15 function in cold weather.
Okay.
There's some other Googles if you'd like to pull it up.
Well, I've got those and we're gonna go through those. And we'll have an opportunity to do that, but,
And that was the night Tammy was shot at.
okay. And he Googled that night, right?
That's correct.
What time of night was that, do you recall?
I'd have to look at my notes.
Okay. Okay, but he also had a habit of Googling a lot of things, right?
I can't answer that.
Well, you know about the Hannibal Lecter thing, right?
No, sir.
Okay. Well, before we get to the Hannibal Lecter thing, let's talk a little bit about some of the other searches from Homer J. Maximus. October 21. Best tactical cutting moves, right?
Correct.
See that one?
All right, and Mr. Pryor, you're gonna have to stay by that microphone or we don't pick up what it's said.
Good judge. October 22nd, 2019. Sharpening swords. Knife sharpener, right?
Correct.
Okay, what was the date of Tammy Daybell's death?
October 19th, 2019.
Okay, so 3 days after Tammy Daybell dies, Alex Cox is still looking at sharpening swords and a block knife sharpener 3 days after Tammy Daybell's death. Is that right?
Correct.
Okay. October 23rd. 4 days after Tammy Daybell's died. 15 facts about the silence of the lambs you didn't know. Call that one?
No, sir.
Okay. And that was 4 days after Tammy dies, right?
That's correct.
Okay. Now, when you searched, and I believe it was 107, was that the unit that we found all of the knives and the guns?
No, sir, that was 175.
Okay, 175, that was Lori Vallow's unit then, right?
That was the unit that Lori Vallow lived in, but Alex Cox was on the tenant agreement.
Okay, okay. And your testimony previously, I believe that was a day or so ago, there were a significant number of weapons found, right?
That's correct.
Did you do a check on all of those weapons to see who they belonged to?
I personally did not do a check on all those weapons.
What about the knives or the ammunition? Did you check and see who those belonged to?
I'm not quite sure how to check on who the
I
knives
don't
belong to.
I don't either. I just asked because are you presuming that the owner of those knives and guns and ammunition is Alex Cox?
They were found amongst his belongings, so I presume that is.
And we talked about this before, when I was doing some voir dire and native objection, that a lot of those items were items, the knives and the ammunition were items that you pulled out of bags and displayed for purposes of, for lack of a better word, staging them for your photo op, right?
That's correct.
Okay, okay. But again, all of the ammunition, all of the weapons, all of the knives, and the ski mask, that was found in Alex Cox's, at or near Alex Cox's belongings, right?
Correct.
So I don't want you to speculate, but you're presuming that Alex Cox owned all of this, right?
That's correct.
There's no indication that Lori Vallow had several guns and knives and things like that. Is that fair?
That's fair.
Okay. I want to switch gears a little bit. And I want to talk to you a little bit about Charles Vallow. Okay? And I assume you've been communicating with the folks down in Arizona about all of that. Is that fair?
Yes.
Okay, so you're well versed in the facts as it relates to Charles Vallow, correct?
No, I wouldn't say well versed. I know the basics.
Okay, but are part of the basics to know where the court proceedings are and who was charged with what?
You would have to be more specific.
Okay, and do you know currently who's charged in the death of Charles Vallow?
Yes.
Okay, who is that?
Lori Vallow.
Okay, are you aware that the prosecuting attorney down in Maricopa County issued a
Objection to your say.
That's the same.
Judge, I'm asking whether he's aware, not whether he,
Well, by the time you say what he's aware of, then all the information's coming through his, so it's the same.
okay. Are you aware that Chad Daybell is not charged with anything in Maricopa County relating to Charles Vallow?
Yes, I am.
Brandon Boudreaux's next. Who's been charged in the allegations against Brandon Boudreaux?
Lori Vallow.
Is there anybody else?
Not that I'm aware.
Okay, and you're also aware that Chad Daybell has not been charged in the allegations as they relate to Brandon Boudreaux, is that right?
That's right.
Okay. Now, if Alex Cox was still alive, the suggestion seems to be that he would have been charged with both of those offenses. Would that be fair?
Objection calls for speculation.
It's the same.
Okay. Do you have any information as to who killed Charles Vallow?
Yes.
Who do you believe killed Charles Vallow?
Alex Cox.
Okay. Who do you believe took the shot at Brandon Boudreaux?
Alex Cox.
Okay, thank you. Now, did you have the occasion to look into the history of Alex Cox a little bit?
Briefly.
Okay, were you aware of an incident that occurred in, let me get the date right, August 5th of 2007?
You'd have to be more specific about what occurred on that date, sir.
On that date, there was an allegation that there was an assault on a Joseph Ryan.
That's correct.
You're familiar with that, is that right?
Yes.
And in 2007, is there any indication that Chad Daybell knew Lori Vallow in 2007?
Not to my knowledge. No.
Okay. And in that incident, are you aware that Alex Cox committed aggravated assault on Joseph Ryan?
Your Honor, at this point, I'm going to object to relevance.
I think we're outside the scope of what's happening in this case, Mr. Pryor.
Judge, can I approach, please, counsel?
Sure, outside watching.
Okay, I think the microphone is on. Hopefully you can hear me. I think it may have been off when I was talking before. Obviously, okay, it looks like Pryor is back.
But
All right,
I just
we'll
wanted to
talk about it a second.
reiterate, we had an objection that was sustained on relevance grounds, and the court confirms that objection, concluding under 403, it's not relevant for purposes of this case.
Judge, based on that ruling, the state would move to strike the question.
All right, no questions stricken on that topic won't be allowed.
I would like to talk to you a little bit about Chad Daybell's phone, and I'd like you to refresh my recollection. Okay? Yeah. You made mention that on the 26th, when you were doing the initial welfare check, you followed up with calls to Mr. Daybell, is that right?
That's right.
And your testimony was that you weren't able to get an answer, or the phone was turned off?
Every time we called, it went straight to voicemail, I believe.
Oh, all right. Did you have an opportunity to go through Mr. Daybell's phone records?
I personally have not, no.
So there's no indication that the phone was ever turned off, was there?
I can't testify that I didn't go through these records.
But you can testify that it just went to voicemail.
Correct, I can testify he didn't answer.
Okay. Now, when you searched Lori Vallow's residence, there weren't any clothes in there. In the residence that she had hanging up on hangers, right?
That's correct.
Do you have any information to suggest that she had mailed or shipped her clothes to another location?
No, I don't.
Okay. And then you, at the time, you were aware that Mr. Daybell obviously was married to Ms. Vallow at that point. Is that correct?
That's correct.
And is it your allegation that Mr. Daybell left on the 26th or 27th and also tried to avoid contact with law enforcement?
I can't answer why Mr. Daybell left. All I can answer to is I wasn't able to get a hold of him after that date.
Okay, and after that date, did you happen to check credit cards or phone records or anything like that to try to locate him?
Again, sir, I didn't go through Mr. Daybell's phone records.
Okay. Did you gain any information that Mr. Daybell was going on a vacation around the 26th or 27th of the end of the month?
We later learned that Mr. Daybell was in California.
Okay. And later learned that he was in California, and that was about the time of the 28th or 29th of November. Is that right?
I'd have to refer to my notes.
Okay. And were you aware?
Sounds right.
Okay. And again, maybe the coffee's still affecting me. I'll try to slow down. Okay. But you're also aware that Mr. Daybell on the 28th being at Knott's Berry Farms, right?
Correct.
And that was a family vacation with his kids, correct?
I can't testify to who was there.
Okay, so Mr. Daybell wasn't fleeing. He was on the 26th or 27th of the month when Lori Vallow's closet was empty. Mr. Daybell was on a family vacation.
I can't testify that he wasn't fleeing. I can testify that I knew he was in California at a later date.
Okay. And you know that later date was the end of November, right?
Close to that date, sir, yes.
Okay. And you know that subsequent to that, then he went on a trip to Hawaii after that, right?
Yes, he was in Hawaii after that.
Right. So if I understand the testimony, Mr. Daybell was at some point after the 26th, went on a planned family vacation at Knott's Berry Farms, right?
I can't testify it was a planned family vacation.
Okay, all right, that's okay. And then subsequent to that, he then went to Hawaii on a trip to Hawaii where there was some contact with you folks, correct?
Yeah, we made contact with Mr. Daybell in Hawaii.
Okay. And how is it that you found it out that he was in Hawaii again? Remind me.
Through tips that came in through our hotlines that we had set up and cell phone data.
And this is just a question, I'm kind of curious. Did maybe you just look at plane records?
Are you asking?
Yeah,
if I-
I'm asking, did you guys look
I'm
at?
sorry. I can't.
Oh, I'm sorry. Go ahead, I'm sorry, sir.
Can you repeat the question, please?
Did you just, did at any time, did you just take the initiative to look at plane records?
So each officer was tasked with different things.
Okay.
We did have an officer that looked through financial, and I assume he did look through plane records and credit cards.
Okay. And, if Mr. Daybell was flying on a commercial plane or traveling from Boise to Knott's Berry Farm on a commercial plane, in your experience and knowledge of these things, there would have been a record of that, right?
That's correct.
Okay, all right, thank you. Now, I'm going to switch gears again a little bit, okay? Please forgive me because I just want to make sure I hit all of these subjects. And before we go there, I want to make sure you did get a subpoena from my office, is that correct? That's correct. And you've acknowledged that you've accepted that, correct?
Right.
And you were kind enough to contact my office and agree that if I need you to come back, you'll come back at a time that's suitable for both of us. Is that fair?
Yes.
Was there anything else discussed during that phone conversation?
Date said I couldn't make it back.
Okay, and that was because, and we're not going to get into this to let everybody know, because it's nobody else's business, but you have an obligation of some sort, and I've acknowledged that, and we're going to work on that. Is that fair?
Objection relevance.
Sustained.
Okay. Now, as part of your investigation, and I want to be specific to JJ Vallow, okay? The last known sign of life was the 22nd. Is that fair?
The last
time that someone known.
was September 22nd of 2019.
Right, okay. And the last, at least proof of life for Tylee Ryan was September 8th
Of 2019.
of 2019. So I'll do the math in my head if I can. There's 15 days difference between Tylee Ryan and JJ Vallow. Is that correct? For the last proof of living or life, respectively.
Roughly.
15 days. You think JJ died on around the 9th of September, 8th or 9th of September, and Tylee was the 22nd or 23rd. Is that fair?
That's correct.
Okay, thank you. Now, as part of the investigation, you looked into where JJ Vallow was on the 22nd of September, correct?
Correct.
And on the evening of the 22nd of September, he was at Lori Vallow's home.
That's correct.
Okay. And present at that home, staying in that home, were Lori Vallow, correct?
Correct.
At least on the 22nd, JJ Vallow was there, correct?
That's correct.
Melanie Gibb was there, correct?
Correct.
And David Warwick was there.
Correct.
Okay. And on that evening, they were conducting some sort of a religious podcast, the three of them, correct?
Yes, sir.
And the allegation is that JJ was acting up and went into the care of Alex Cox.
Correct.
And then Alex took JJ into a separate apartment, correct?
On which day?
On the 22nd?
He took him to apartment 107. Correct.
Right. His apartment or whoever was on the lease for that apartment, right?
That's right.
Okay. And then the last time that anybody saw JJ was later that evening, is that fair?
Yes.
And that was when Alex Cox was carrying JJ Vallow into the apartment of Lori, David, and Melanie Gibb, right?
Correct.
Who were all staying there together, correct?
That's correct.
And then somewhere at that point, whether it was at that point or subsequent to that evening, or that evening, that's when you believe that JJ Vallow was murdered.
That's correct.
Okay. But the next morning, there were three people in the apartment at that time early in the morning, correct?
Objection foundation.
Well, do you know who was in the apartment early that morning on the 23rd?
Hold on, prior, there's an objection, I think that would go on, sustained.
Do you have any knowledge of who was in the apartment on the 23rd of September, the morning of that morning of 2019?
Yes,
And who was there?
David Warwick, Melanie Gibb, and Maury Vallow.
Okay, and at that point, you believe that JJ Vallow was already dead?
I can't testify to the time, but I believe he was killed.
Okay, but then within 2 hours later from that morning, you believe that he was buried on Chad Daybell's property, is that right?
That's correct.
Okay. Okay. You had an occasion to talk with Melanie Gibb and David Warwick, is that right?
That's right.
Now, you did it a couple of times, if I recall, one by phone, right? With Melanie Gibb,
Correct.
and that wasn't recorded, was it?
It was recorded
It was recorded?
with her attorney.
No. No, I'm talking about a regular phone call with Melanie Gibb, without an attorney.
I don't remember a phone call.
Okay, all right, we're gonna revisit that maybe at another date, but that's fine. But you also went down to Provo, Utah. And I'm going off of memory, but it was Provo, Utah on the 4th of June of 2020, is that right?
Sure.
Now, at that point, you were interviewing both David Warwick and Melanie Gibb about information they had about these allegations, correct?
Correct.
Okay. And who else was there?
Myself, Lieutenant Ball, and Prosecutor Wood.
Okay, so the prosecuting attorney, Mr. Wood, right there. And a lieutenant that you work with and yourself drove down to Provo, Utah.
Correct.
And was there anybody from any local law enforcement there as well?
No.
Okay, now there was an effort to record that conversation, is that right?
Yes, it was recorded.
Okay, was the entire thing recorded?
I believe the very beginning wasn't. The recorder malfunctioned or something happened that was recorded, but the majority of that interview was recorded.
The majority of it was.
That's correct.
So if I represent to you that there was 22 minutes of recording on that interview, does that sound about the length of what the interview was with Melanie Gibb?
No,
It doesn't?
No.
Okay. Would it be helpful if you were able to listen to that recording and view that recording to refresh your recollection?
refresh my recollection.
Like about the length of time that recording was?
It should have been longer than 22 minutes. We were there longer than 22 minutes.
How long were you there?
Roughly, say about an hour, maybe.
Okay. Now, your testimony is that it should have been longer than 21 or 22 minutes, is that right?
That's correct.
Would it surprise you to learn that, well, you don't know exactly how long that interview took place, right?
Yeah, I couldn't tell you the exact time.
And you don't know the length of the recording itself, is that fair?
That's fair.
Okay, and in order to determine that, it would be helpful for you to refresh your recollection by listening to the interview, and it would be able to answer those questions for you. Is that fair?
That's fair.
Your Honor, I'm going to object beyond the scope.
We're way beyond the scope of your red counsel. If also the officer's going to review that, and I permitted, of course, it's not going to be in the presence of the jury. So also saying the objection on beyond scope.
Judge, are you talking about beyond the scope of direct examination?
Yes.
Okay, then officer, we'll revisit that at another time, okay? And we'll leave that for another opportunity when I call you back. Now, on the day that JJ Vallow was found in on June 9th. Okay? The pictures and the testimony you showed suggested that he was wearing, red pajamas and some Skechers socks. Is that right?
Sure.
Okay, do you have a recollection of what JJ Vallow was wearing based on your investigation when he was carried by Alex Cox from Alex Cox's apartment to the upstairs of Lori Vallow's apartment?
Objection, this calls for hearsay.
It doesn't necessarily call for hearsay. He's wondering what he observed him wearing, if you know, so
Yes,
that's what we'll rule on that.
tell me if you know the answer.
I don't know the answer to that question.
Okay. Do you know whether or not JJ Vallow was wearing red pajamas when he was carried upstairs by Alex Cox?
Sir, I don't know the answer to that
Okay.
question.
And Judge, I think at this point, I'm going to save the rest of my questioning for when I call the officer back in my case in chief. That's okay.
Very well. You can do that. I'll conclude the cross-examination then. This time we'll begin with redirect from the state. Mr. Wood.
Your Honor, may I be handed States Exhibit 31? Yes, and States Exhibit 30. Detective, you testified earlier about when you first met Alec or Chad Daybell.
Correct.
Who was he with?
Alex Cox.
Did he look afraid of Alex Cox?
No.
Alex Cox was Chad Daybell's brother-in-law, correct? When you met him?
That's correct.
Detective, you were asked about your beliefs. Is that fair? In cross-examination, you were asked about your beliefs?
Yes.
Let's talk about your investigation. When you started your investigation, what was the scope of your investigation?
Initially, it was to find the Jeep from Gilbert, Arizona.
And then it expanded, correct?
Correct.
And then what was the scope of your investigation?
To find the whereabouts of JJ and Tylee.
And all this time, you're collecting information from various sources.
That's correct.
Your Honor, may I publish States Exhibit 31?
Yes.
Detective, you were asked about your beliefs, correct?
That's correct.
And you were asked about your beliefs regarding, I'm going to call it the paintball incident. Is that fair?
Yes.
And when I'm talking about that, to your understanding, what am I referring to?
The attempted shooting of Tammy Daybell.
And you testified you don't believe it was a paintball gun.
That's correct.
So why not?
Through our investigation, we learned that Alex Cox was in the area and on the property of Chad Daybell the morning that Tammy Daybell was shot at October 9th. through Google searches from Homer J. Maximus, which was Alex's Google account. The night that Tammy Daybell was shot, it was a colder evening. And the Google searches were how to make an AR-15 function in cold weather. And without referring to my notes, can I refer to my notes?
Would it refresh your memory to review your notes?
Yes, sir.
Your Honor, may the witness look at his report.
No objection.
Yes, you can look at it, not to testify from, to refresh your recollections, so once you looked at that, it's now.
On October 8th, the night before, we believe Tammy was shot at, Alex is Googling drop yardage from 300 yards to 100 yards. Which we assumed, when you're shooting a rifle, you're adjusting your sights to your target. That was the night before. The morning of the shooting, Alex was on Mr. Daybell's property. We have him driving up and down the road of Mr. Daybell's property and also on the property. Later that evening into the early morning hours of October 10th is when he Googled how to make your AR-15 function in cold weather. So that's why we believe that it wasn't just a paintball gun. We believe that Alex Cox was there to shoot Tammy Daybell.
Okay. Because I'm gonna have you look at this timeline. And as far as you're aware, these dates are accurate, correct?
I'm sorry.
As far as you're aware, these, in pursuant to your investigation, these dates are accurate, correct?
That's correct.
Did the fact that Tammy Daybell died 10 days after that incident have any bearing on whether or not you believed it was a paintball gun?
Yes.
Did the fact that Chad Daybell got married 17 days later have any bearing on your belief whether or not it was a paintball gun?
Yes.
The fact that there were 2 children buried on Chad Daybell's property have any bearing on whether or not you believed it was a paintball gun?
Yes.
Did the fact that Lori Vallow's husband died within months of these other deaths have any bearing on your belief of whether or not it was a paintball gun?
Absolutely.
And finally, did the fact that Brandon Boudreaux was shot at on October 2nd, 2019 have any bearing on your belief of whether or not it was a paintball gun?
Yes.
And it's your belief that Alex Cox was tied to these events, correct?
That's correct.
And because you were asked about your beliefs, was it your belief that Chad Daybell was tied to these events?
Yes.
Why?
On our investigation, the lies that we've been told, the fact that we tried to get a hold of the kids' mother, Lori Vallow, kid's stepfather, Chad Daybell, their uncle, Alex Cox. We weren't able to get a hold of anybody. We were left in the dark. Based on all those events, that's what our beliefs were as collectively.
Pursuant to your investigation, you know when Alex Cox died?
December 12th, 2019.
At any time after Alex Cox died, did Mr. Daybell call the Rexburg police to report that there might be dead children located on his property?
No, he didn't.
Did he call the Rexburg police with any concerns that perhaps his wife had been harmed by someone?
No, he didn't.
Did he call the Rexburg police before Alex Cox died to say he might be in danger?
Judge, we're going beyond the scope, but walking through our desk, there would be an opportunity to revisit those issues.
I'm gonna sustain that objection.
Okay.
So
Again, so the first time you met Chad Daybell, what was the first thing you asked him? When you had an opportunity to speak with him?
Has to be answered.
This is a response to the cross, your
Overruled.
I asked him when the last time he saw JJ Vallow was
And what did he answer?
in October in apartment 107 with Lori Vallow.
And did you ask for Lori Vallow's phone number?
I did.
And what was his first response?
Judge, this has been asked to be answered.
This is a response to the cross.
overall,
His response was he didn't know her cell phone.
Detective, you were asked a little bit about how you do an investigation. Correct?
Correct.
And we spoke about the scope of your investigation in this case.
Correct.
It was your testimony that you followed where the evidence took you in this case.
That's correct.
No further questions, Your Honor.
all right, Mr. Wood.
Judge, there were some issues that were opened up. I'd like the opportunity to revisit this.
There were a few, so I'll allow a limited recross, particularly considering your statement, you're gonna recall the witness, it'll be limited, but if you'd like to, Mr. Pryor, you may.
Detective, there was some testimony about, I'll wait for you to hear.
Thank you.
There was some testimony that you had the whereabouts of Alex Cox on the property of Chad Daybell, and that would have been on the 9th
That's correct.
of October.
Yes,
Do you have a recollection of how long he was there on that property?
I don't.
Okay, and you're basing that knowledge on his phone records and his pings, right?
Correct.
Did you have an occasion to look at all of Alex Cox's whereabouts on that day by way of his phone records, or did you just look at that specific time?
We were more interested in that specific time.
Okay, and I gather from your testimony that you didn't look at between 8 and 10 o'clock on the 9th when the paintball incident took place. You didn't look at that time for Alex Cox's whereabouts, did you?
If I remember right, I didn't get his location near the property at that time. There was no location.
Okay. And isn't it true, officer, that you didn't get his location at that time because Alex Cox's phone was pinging in Idaho Falls at that time, some several miles away?
I can't testify to that.
Okay, but you know he wasn't on the property by way of his phone ping and then all of the metadata, that's the word you used, right? Metadata? By the metadata, Alex Cox wasn't on the Daybell property when Tammy Daybell was shot at with a paintball gun, correct?
No, sir, I can't answer that. I can answer that Alex Cox's cell phone or his device was not on the property.
Okay, and you can also say that his device was on Chad Daybell's property sometime in the morning of the 9th of October, right?
And driving down the roadway in front of the property.
Right. And we don't know who else was on the property on the 9th of October, do we?
I can't testify to who was on the property.
Right. So we don't know if he was there by himself or is he there with other folks, correct?
That's correct.
Okay. And when we're talking about you've been on the Daybell property, right? A couple of times.
Yes.
And you took a photo of the car, and we're gonna revisit that next time we get together. But it's not 100 yards from the end of the Daybell driveway to the road, is it?
No, sir.
Do you have an idea of how long that driveway is? Could you give me an idea if you know? If you know,
I couldn't testify to that.
is it 50 yards?
No, I would say maybe 30, maybe
30 yards?
20, 30 yards. Yeah.
So 60 to 90 feet.
That's my rough guess, yes.
Okay, so if we're looking at a rifle at 300 yards and dropping it down to 100 yards, we don't need 100 yards to get from one end of the Daybell driveway to the other, do we?
What our investigation or our belief was, if you're asking me what my belief is,
No, I'm asking you the distance down the end of the Daybell driveway to the top of the Daybell driveway, that's not 100 yards, right?
well, that's correct.
That's all I have, Judge. Thank you.
Mr. Wood is the state road call next witness.
Your Honor, can we approach?
Yeah.
Your Honor, I made this witness leave the stand.
Oh. I didn't know we are. You want to have the sidebar first?
No, we're done.
Okay, well, Lieutenant Hermosillo, you may go ahead and return down. And because you are still under subpoena, maybe recall, I will admonish you to abide by the court's exclusionary rule. You're not permitted to review or view testimony trial between now and the time you return testimony. If you fail to follow that and follow the trial or observe any testimony, you will not be permitted to testify again. All right. Okay, thank you.
All right, so we're having another sidebar here at the trial of Chad Daybell. The detective just got off the stand. I believe he's been our first witness. I've been having to do some other things, but I believe he's the first witness in the case. And a little unusual that the prosecution was objecting to some of the line of questioning as it relates to the officer on cross-examination by John Pryor. Normally, the judges will allow a little bit of leeway because it's cross-examination and you don't want to have to inconvenience the witness. But Mr. Pryor stated that he has the detective under subpoena and that he will be potentially called back in the defendant's case in chief. Like I said, normally unless it's just completely irrelevant, everybody lets the cross-examination take place. So you're not extending the trial, inconveniencing witnesses, things of that nature. But the prosecution objected to one point as it related to the length of time of the audio recording that they had versus the amount of time that they spent with the witness. What's her name? The one that was there the night of the podcasting. Oh, it's escaping me. Anyway, Melanie Gibbs. There it is. Thank you, Frank. And it was Melanie Gibbs. And it's like, well, there's 22 minutes of it, but you were there for an hour, and there's kind of back and forth as it relates to that. So Pryor's like, fine, I'll just bring you back. You guys want to play silly little games? We'll do that. Now, I know a lot of people don't like Mr. Pryor. I think he's doing okay. Okay. This is kind of a style that you develop. You have to do your own thing. And Pryor's kind of like, well, how far is that? Tell me again. I'm kind of playing a little, I'm just a little unsophisticated lawyer here. Why don't you tell me, Mr. Sophisticated Police Officer, how longer was that? Was it 30 yards, 60 yards? Okay. 3 feet in a yard. Yada. Okay. So 90, well, you wouldn't need that much time to get, back and forth. Now, it's kind of a style that you develop. On cross-examination, you can go in there and say, the driveway was 90 yards. He was not home on that day. Yes or no, right? It's very dry. It's very boring. So you try to make your cross-examination be like a conversation that you're having with the witness on the stand, but you phrase it. Pryor's up there like, so would it be fair to say, I don't want to put words in your mouth, you would say that this is, what is taking place? Yes. You want to have it as a conversation, but yet still giving yes or no answers, questions that require yes or no responses, and sometimes you're gonna say, well, and it may seem like, well, this is obvious. This is just boring. Why is he asking that question? Okay. Well, let's just be clear. On the date in question where you think that JJ was killed, let's just be clear. Tell me once again, where was Mr. Pryor? Oh, he was on a family vacation in Knott's Berry Farms. Okay. And so if he's there, then he obviously can't be there. It may seem obvious, but remember, these attorneys, people that have been following this case, they know the facts, right? We all know the facts pretty well. May not have all the dates down, but we generally know the facts. So you have this jury that doesn't know the facts as well as people that have been paying attention. Part of the reason why they're there, they know little about the case. And so he's trying to primacy and recency of the facts that he wants. And remember, neither does the prosecution nor the defense, just usually have this smoking, knockout punch that's just going to win the case. It doesn't happen. I mean, every now and then it's wonderful. You get those Perry Mason moments. I love it. But it's the exception to the rule. And it is equivalent to like putting a puzzle together. Okay. You have your puzzle, the little pieces, does a puzzle just all fit in one big thing? Oh, all of a sudden it just falls into place. No, you have to put it there. You put it in, you put a little piece, you put a little piece in, you put a little piece in, you get this from this witness, a little piece from this witness, and it ultimately gives you to the bigger picture, which you ultimately try to pull together in your closing argument. And sometimes it's just, it comes together. You may seem like, okay, don't really get well that came in for this particular moment, but trust me, there's usually a method to the madness. This witness may not have personal knowledge, so the attorneys are trying to get what they can out of this particular witness. And like I said, it's not going to be like bleh, every good fact that you want all comes together. It is a pieces. Like I said, the best way analogy is you have your puzzle, you put it on the floor or you put it on the table, you dump it out. Does it all just automatically fall into place? No. You take your little piece from this witness, you put it together, you put it together. And hopefully, by the time you get done, your puzzle, if you're the prosecution, says guilty. And if you put your little puzzle together and you say, oh, we took all these pieces and here's this piece and we put this piece together. And then you get to the end of it. And what does it say for the defense? It'll say not guilty. So that's what you have to, try and remember. The prosecutors can kind of get up and say, we are here for the people. Tell me what happened, detective. What happened next, right? The defense has a little more difficult game to play, process to engage in, because first of all, they don't like your client. He's accused of murder. You know, there's going to be people say, well, I'll give him the presumption of innocence, but hey, if there's smoke, there's fire. What is he doing here? There must be something, and they're always looking for that. So as a defense attorney, you gotta be nice, but you gotta be aggressive sometimes. You got to stand up to the judge.
All right, counsel, if you'll give me a moment, I want to
We're back.
clarify our record on exhibits admitted through that last witness and make sure the court has a clear record of what came in as it relates to exhibit 34. So we did have a stipulation that on the record here, and for the jurors to know as well, we had, I believe 34 had separate attachments or would be separate exhibits, 34A, B, C, D, and E. Is that what 34 consists of?
Yes, Judge, and the state is stipulated to be admission to all of 34, which included those separate exhibits. They've already been.
Okay, and understanding they were stipulated to, but still on the record, I'm going to make clear that exhibits 34A, 34B, 34C, 34D, 34E have all been admitted into the record and are evidence in the case. Does the state concur with that?
That sounds accurate, Your Honor.
Okay. Counsel, when we conclude, I'll have you stick around for a minute to also see if we need further clarify exhibits on the record. At this time, ladies and gentlemen of the jury and those in attendance, I've discussed scheduling here with counsel. We got this trial started and moving along with jury selection a little quicker than anticipated, and the state is at its stage of putting on its case in chief. They're doing their best to line up witnesses to appear here, coming a little sooner than anticipated. And that's the explanation. We are going to go ahead and conclude for today in order to allow the state to have a full day's worth of evidence and testimony beginning on Monday. And then next week, we should be on a full slate of Monday through Friday trial. Notice also, as I mentioned previously, that tomorrow is not going to be a day of trial. So as I understand it, the state would request that we then conclude trial for the week and commence again on Monday morning. Is that correct?
Yes, Your Honor.
The state, or I'm sorry, does the defense have any objection to that?
No objection, Judge. Thank you.
Okay. So before you leave then, ladies and gentlemen of the jury, this is a pretty long break in between evidence now that you are sworn jurors in the case. And I will again admonish you to please do everything you can to not do anything to learn about the case, investigate the case, look the case up, follow any media in the case. If you do see anything being reported, try to avoid that. Don't talk about the case to anyone else or any of the evidence or facts with anyone, including with each other. You can only do that when you start your deliberations. And when you return on Monday morning, when we'll commence at 8:30 with more evidence, I will be asking the jurors as they return to complete those admonitions and certify under penalty of perjury that you have followed that instruction. So I appreciate you doing that so far. I have confidence you will continue to do that. And thank you for your time and efforts today. That will conclude our trial for today, and we will resume again on Monday with further evidence.
All rise, please.
All right. So I guess technically the second day of trial testimony, not counting jury selection, the second day of trial testimony, one witness, right? Correct me if I'm wrong, Frank. One witness?
Yes.
This has been one witness. It is now 1:30-ish in Boise, Idaho. And the prosecution does not have any more witnesses lined up ready to go. You got to be kidding
Thank
me.
you. Please be seated.
Really? Oh, all right. Looks like the court's going to conduct a little more business.
The
Let's back to
matter on the exhibit 34 is the court is referencing the defense trial exhibits, and 34 is listed. It says 34A through E. Alex Cox Google searches in October 2019. There's also a 34F and a 34G through J and a 34K through Y. So I just wanted to make clear what came in the record today that will be admitted. We have 34A through E.
That's correct. The other ones are yet to come.
Okay,
So, and I'm sorry, it was confusing. I tried to do this as plainly as possible and have it all on a thumb drive so that the court can make it easier for the jury, but, at this point, it's only 8 through E. The others have been admitted, Judge. I just haven't referenced them yet.
okay. And just to be clear, even though admitted or and agreed to be admitted by stipulation, for this record to be accurate and for future reference to the record, each time a new exhibit is referenced, it needs to be just called out on the record so the clerk keeps an accurate list of what exhibits have come in and that those track with the actual exhibits. So I think the system works. We just need to make sure that individually, for example, with that, if there's multiple exhibits within a number, then we outline exactly what came in. That way we make sure the jury doesn't see any evidence they weren't supposed to see and they see all the evidence they are supposed to see. So we'll continue to work on that process as we start next week. Before we conclude today, then, is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor, thank you.
All right, thanks everyone in attendance today also for following the court's conduct orders. I appreciate it very much. Moving to recess for the day.
All rise, please.
Okay. All right. Let's see here. Hold on. All right, we're back. So, day 2 of trial testimony, 1 witness down, and we are taking a break for the weekend. No court tomorrow. I mistakenly said it was 1:30 because very odd. The Koberger case didn't start until 4 p.m. yesterday, which was 5 p.m. our time here in Denver, Colorado. And they started at 8:30. Frank confirmed to me, and that was 8:30 our time. So maybe up there in Moscow is a different time, Pacific, I guess. Maybe, I don't know. I'll have to look it up. Anyway, they're done for the day. 2:27. The detective was on the scene, kind of giving a big overview. And when the defense tried to get into a little more specific information, the court shut them down as it related to, some of the evidence. But it is what it is. It's done. Now, some people say, well, they want to start with a fresh witness. I can tell you most judges, I understand they've been seated in a jury for 6 days. I get that. The most judges would be like, call your next witness, prosecution. We're going to utilize the jury's time efficiently. We are going to be as efficient as possible, because these people have given the jury has given us their time, and we are not going to waste it. So, little surprised the court didn't say, okay, it's 2:30, call your next witness. We still got another couple hours here that we can make some progress on, but apparently either they didn't have it, or they convinced the judge, let's just stop for the day. Either way, they're done for the day. No court tomorrow. Pryor's cross-examination, it's his theory, right? Alex Cox, Lori Vallow, evil people. They killed JJ. They killed Tylee. They killed Tammy, just like they shot at Boudreaux and killed Charles Vallow in Arizona, which coincidentally Lori Vallow just happens to be charged with, right? That's the theory. Lori Vallow, her brother, Alex Cox did it. They're the evil people. My poor innocent client, Mr. Daybell, got played by this black widow woman. Everybody winds up dead around her. I was joked early on that Chad Daybell never thought about getting out of custody at when the charges were, because he probably figured it was safer for him in custody than out of custody, where somebody associated with Lori Vallow could get him. So you just never know, and I was kind of explaining while they were at the sidebar, this trial is set for 8 weeks. It's going to be long. It's going to be tedious. It is going to take some time. It'd be nice if you could just get all the good facts in, but you have to have the witnesses that have the personal knowledge to come and testify, right? We do not allow hearsay evidence generally. Of course, there's lots of exceptions to the hearsay rule, but generally, and you can always remember this, all right? This is a general rule for hearsay. If somebody on the witness stand is going to testify as to what somebody else, right? We can only have one witness on the witness stand at a time. So that person on the witness stand cannot testify as to what somebody else said, what they wrote, what they observed. That would be hearsay. You have to bring that witness in to hear what they have to say. What did they observe? And they have to be subject to cross-examination. So that is why sometimes it takes so long. That's why you need so many witnesses. And generally, like I said, you don't get to talk about what somebody else said. Otherwise, who do you think the prosecution would call? They would call that their lead detective. Did you interview this person? I did. And what did they tell you? Well, they told me this, 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 and this. We don't do that way. That was the way the old king used to do it. The officer got up and said, I'm here on behalf of the king, and I assure you I'm telling the truth. We never do anything wrong. And all of a sudden, they just start regurgitating what somebody else said to them. We don't allow hearsay evidence. You get to see the witness, right? The confrontation clause. Remember what I keep talking about? The Constitution matters. Where do you think that right to confront witnesses and evidence brought before the court against the defendant comes from? The confrontation clause in the Constitution, ladies and gentlemen. It is a big deal. And it is been described as the greatest truth-seeking tool ever invented. You don't get that kind of on the talking heads, so to speak, on just about anything else, whether it be politics or even the law. They talk about it, but when you actually get to have the witness there, subject to cross-examination, and I've made the argument many times. I mean, ladies and gentlemen, the prosecution and the defense, they're advocates for competing interests. One is for the prosecution, the government. The other is for the defendant. Because prosecutors always say, we're here to seek the truth. We're here to make sure everybody understands, and this is a quest for the truth. I say, you betcha. You betcha, ladies and gentlemen. If it was a quest for the truth and the prosecution was going to do that, I wouldn't have to answer. I wouldn't have to get up and ask a single question as a defense attorney, because the prosecution would have answered all of the information that everybody desires, and there'd be no need for me to ask anything. But then I say, do you remember what, ladies and gentlemen? On cross-examination, it was the defense that the witness said, oh, they really didn't see it. Oh, and that wasn't the way things went down, as the prosecution tried to describe it, perhaps in their opening statement. So that's why cross-examination is so important. And that's why the judges in the court instructions say the jury can only listen to legal and competent evidence, which is evidence that is properly admitted by the appropriate foundation, the appropriate rules of evidence being complied with, so that it is admitted into evidence, and that the testimony is legal and competent evidence, which is people can testify as to their personal knowledge of something that took place. That's what that comes down to, and that it has to be subject to cross-examination. Okay. No cross-examination, not good. Not good. You can't be trusted with that information. The court will tell you can't consider it until cross-examination has taken place. And maybe it's enough to sway a juror, maybe it's not, but that's the requirement that needs to take place. So if it's done, it's done. The evidence will tell the story, then decide. Who cares about the BS excuse? If he's done it, he's done it. Well, Patty, and I get it. And remember, I've said this all along. I have to tell this to my clients all the time. Listen, man, I don't care what you did or didn't do, or you think you did or didn't do, or if you're justified or not. By the time charges are filed, somebody's arrested, charges are filed, whether there's a plea disposition or you go to trial, the truth or a pretty darn close version of the truth is going to come out. So if you think you're going to hide it, beware. Don't do that. And so you have to be prepared for that. And that's what I said. The truth will come out. And think, oh, people are going to say this, or they're not going to say that, or they're not going to show up. I always assume they are, and I assume they're going to, you have to assume that they're going to say what they've put in their statement the first time. And even then, it doesn't matter. All they need, the prosecution, they don't care what they said in a subsequent statement. They got the first statement given to the police, and the prosecutor's just like, I just need you to get on the stand, man. Just get on the stand. I will put up the officer who, if you recant your statement or something along those lines, the district attorney will simply say, that's fine. I will put up non-hearsay evidence, which is evidence that is used to show a prior inconsistent statement, right? Classic case is woman calls the police, says, my husband punched me in the eye. Husband gets arrested. Husband sets the case for trial. Wife is forced to testify. Did you, on the date in question, did your husband punch you in the eye? No. I was just a terrible spouse. I keep walking into the cupboard and I just keep hitting my eye up. Clumsy me. Prosecutor's like, okay, good to go. Let me lay some little foundation though. Do you remember speaking with Officer Smith on this date? And you said this, and oh, by the way, it was just happened to be recorded on body cam. Nope, I don't remember saying that whatsoever. Okay, thank you very much. Prosecutor then brings in the police officer. In the old days before body cams, they said, officer, do you remember this? What did she tell you? That my husband punched me. Did she say anything about walking into a cupboard? She did not. Okay. That is not hearsay. That's an exception because that shows a prior inconsistent statement than the one that she made on the stand. So that always comes in. And today, not only do they have the officer say it, they usually have the body cam say that as well. So hopefully that explains a little bit about that. Hopefully you thought that was something of value, and hopefully you will join us on Monday. Let's see. Anna has something to say, though. Let's see this. Anna. Mr. Pryor came out like gangbuster today, but I'd like to see how he's going to go in about 2 weeks. He's going to wear himself out. There's a lot of evidence to go through yet. Yes. He came out. That's true. And, it's the first witness. Of course, your first witness, you're like, let's do this. When you start getting into witness number 28 after 2.5 weeks, he's going to get tired. Trust me. I've done it before. Marvin, no court tomorrow, but we'll have a show up tomorrow, but no live stream of this trial because it is in recess until Monday morning. So, but yes, I agree, Anna. He's going to have to pace himself. This is not a sprint. This is a marathon. But hey, at this pace, basically doing half days, right? We seated the jury the first couple of days, all of last week. Monday, we took Tuesday off. Wednesday, we went to opening statements. It's Thursday. We've done one witness. Uno. One. That's it. So something to think about. This may take forever, but that's okay. We're going to bring it to you live, gavel to gavel coverage. So I want to thank everybody for watching. As always, you know the drill. Subscribe if you haven't, like if you do, leave me a comment, and make sure you hit that little bell so you get notifications of when we go live or put up new content. All right. You'd be surprised how many people will put it in a comment or even send a DM and say, Scott, I didn't get a message. I thought you hadn't been putting up videos. For whatever reason, something gets reset. So you got to make sure you get those little notifications are there as well. So All right. Have a wonderful day, and we'll see you Monday for the resumption of the trial when we resume the trial on Monday at 8:30. So have a wonderful day, and we'll see you next week on the Chad Daybell trial.